Okay, good morning. Today is 11/25/24, and I want to call the roll. Clerk Jennifer Stellings.
Here.
Alderman Mike Seville.
Here.
Here, okay, and myself, Juani Garza. So we want to start the competition today.
And my name is Ross Seckler. I'm the attorney for the Electoral Board, and I will assist in proceeding through the rest of the objections and the hearings for today. We will start, as indicated in the prior hearing for the three cases up today. We'll start a little out of order because the case 01 will take probably the longest amount of time. We'll call the first case for today, which is case 3, the Tara Loza versus John Leish, Electoral Board case 24 AMOB 003. And if the parties, when they're ready, if they can identify themselves.
Ed Mullen on behalf of the candidate.
Good morning, John Fogarty for the objector.
Thank you, gentlemen. We're starting with this case, of course, because this has one legal issue and one issue, and wanting to get through that, and it also affects the rest of the cases. In the prior iteration of this hearing, the parties presented argument mainly on motions to strike and dismiss, and the board heard those arguments and was able to read through some of the authority that was cited and presented to the board. And so at this time, I guess, if there's any further argument or presentation from the parties, that would be appropriate, and the board can then further deliberate and kind of get through this issue.
I think we have argued this, I certainly have argued it plenty to you, so I have nothing to add in addition to what I've spoken about already.
No further argument.
Okay, thank you. So for this one, if the board wants, I've gone through it and I can make a recommendation, and if the board has questions. So this is a difficult case, and I'll summarize kind of what the parties have argued and filed. So I would recommend that based on the filings, and I don't believe that any of this is contested, these are the general facts we're dealing with. One, the city of Aurora, by referendum, holds a nonpartisan municipal elections, and those are governed by the Illinois Municipal Code, and the specifics about those, as well as the Illinois Election Code. The candidate in this case filed nomination papers as a nonpartisan candidate for the office of mayor of the city of Aurora for the February 25th, 2025 consolidated primary election, and if a primary is not applicable, for the April 1st, 2025 consolidated election. The candidate did personally circulated his own nomination papers, and he did circulate petitions for other candidates for mayor, including Jasmine Garcia as well as Karina Garcia. the candidate's nomination papers includes petition sheets that were circulated by the candidate himself, as well as other circulators, Barry Haywood, Helen Ratzlow, Patricia Joan Drugan, and Sully Khalid. And those circulators are also circulators on other candidates' petition sheets. Neither party introduced evidence, and I think I asked in every case about whether the candidate or candidates assigned as a petition signer on behalf of the other candidates, and neither party produced any evidence, so the board has to assume that he did not. So here the objector alleges that the nomination papers are fatally flawed because the candidate is, quote, a sham candidate acting in concert with other candidates for the office, for the same office to force a primary election, instead of if there were only 4 candidates for the office of mayor, all candidates would go to automatically to the April consolidated election. The objector then alleges that the candidate's statement of candidacy is false. According to the objector, because the candidate here, Jasmine Garcia and Karina Garcia, appear to be are working together as a type of political party in order to force the primary election for the mayor. Even though the city is a nonpartisan system of election, the objector states that 10-4 of the Illinois Election Code, which prohibits different political party circulation, actually applies and should render petition sheets that these different candidates and different circulators should be rendered invalid. As a threshold matter, the candidate states that the objector cites no precedent for that proposition, and that circulators of nonpartisan candidates are not limited to one nonpartisan candidate. The candidate also argues that 10-3 of the Election Code does not prohibit dual circulation for independent candidates, and does not prohibit dual circulation for partisan candidates of the same political party. The same 10-4 has 2 separate prohibitions: that no circulator may circulate for candidates of more than one political party, and that no circulator may circulate for a political party of a political party candidate and independent candidate or candidates. This is a nonpartisan race, and there are no political party candidates, and there are no independent candidates. Everyone is nonpartisan, meaning that that provision could not apply. It requires the existence of a political party that the circulator circulates that the circulator would circulate for, in addition to circulating for any independent candidates. The arguments go into the material differences with 10-4, as well as citing the McGuire versus Nogash case, which says that you can circulate for multiple independent candidates, as well as the McCaskill versus Municipal Office Electoral Board of the City of Harvey, which talks about the section 10-4's non-application to nonpartisan elections, or a candidate who circulated for a Democratic Party candidate and then a nonpartisan candidate was not prohibited. The candidate also raises an issue of whether this electoral board has jurisdiction to even determine whether or not the candidate himself, candidate and the other candidates in the other cases have formed a de facto political party as asserted by the objectors. And alternatively, even if the board is able to, the candidate argues that the mechanisms are created for creating a political party are also defined by statute, and meaning it's based on in 10-2 of the Election Code and having a certain number or percentage of votes at the last election, how you fill those elections. And this is a nonpartisan election, so those would not apply either. The objector responds by citing a federal case, it's Smith versus Cherry, where it's alleged that a group of individuals conspired to place a sham candidate on the primary ballot and nominate a sham candidate, and then had that candidate step aside so that the party leaders could actually approve the real candidate, the preferred candidate. The Cherry court reasoned that if the plaintiffs prove an agreement that Cherry would be a stand-in candidate and show a reasonable possibility that Cherry's sham candidacy affected the outcome of the election, then the district court should order a new primary and general election. The objector also cites to a more recent, the Gonzalez versus Madigan case, where it cites in the court held that an election is just more than the sum of the total votes. It is about the act of voting and an individual's ability to express his or her political preferences at the ballot box. An official who willfully interferes with this act violates the Constitution regardless of whether the vote would have affected the election outcome. And while the objector concedes that the candidate and his cohorts have not taken official action to form a political party under the election code, the objector points out the candidate does not deny that he and the others are working together. While objector admits there is nothing wrong with working together with like-minded people to participate in the electoral process, the objector argues that that level of coordination and candidates accepted assistance or given assistance from his purported opponents to gain place on the ballot and the candidate's presence on the ballot to trigger a primary demonstrates that their activity is tantamount to some sort of partisan activity and calling what the objector asserts as a de facto party. Ultimately, and those are the two sides, basically. Yeah. Ultimately, again, and this is my recommendation. You are the votes, so you vote, and you would decide, and we'll prepare a decision accordingly. But there's two things. Ultimately, it's a difficult case because it's clear that the candidate, along with the candidates Jasmine Garcia and Karina Garcia, purposefully and unabashedly worked in tandem to manipulate the political process, and at a minimum attempted and are attempting to force a primary election for whatever political purpose that may serve. It seems like it's an overt attempt to expend taxpayer resources on a primary election and for some reason, for some political gain reason, and solely designed to influence that electoral process and for whatever perceived specific benefits that will benefit them. The issue, and it's axiomatic that electoral boards cannot close its eyes and ears if evidence and relevant if evidence is presented and arguments are presented regarding to the protection of the electoral process. And that's from Muldrow versus Barron, 2021, ILAP 1st, 210248 at paragraph 49, and also Fortis versus Dixon, 122, ILAP 3rd, 697, 701, 1st District, 1984, which stated within the course of hearing objections to nominating petition papers, evidence beyond specific objections come to the Electoral Board's attention. It cannot close its eyes and ears if evidence is relevant to the protection of the electoral process. Also citing Cantor versus Cook County Officers Electoral Board, 170 ILAP 3rd, 364 at 368. And while the parties agree that there is no explicit prohibition against the candidate and his cohort, what the candidates and cohorts did here, it's difficult to ignore the purpose of the conduct and its intention to essentially delegitimize the electoral process in some way. There is, would want to make further note that there are restrictions on signers of petitions, especially in this case, and they would seem to be more stringent than restrictions on candidates in statute. And that seems to be an absurd result. In 10-3 of the election code, you can only sign for one candidate running for office for independent candidates, and that applies to these types of nonpartisan elections. So why could, a candidate then is still free to circulate and assist other candidates, and the Rosenzweig versus the Illinois State Board of Elections case does talk about that, and that said it would be an absurd result for the legislature to place restrictions on voters that are more stringent than those placed on actual candidates. Under the candidate's interpretation of voters in general, under the candidate in that case's interpretation, voters in general cannot influence the nomination of a candidate from a party other than their own, but a voter who plans to also run as a candidate is allowed to do so. Our Supreme Court has explained that the signature on a nominating petition indicates support to a candidate whose name appears for that office, and cites the Lucas versus Lakin Supreme Court of Illinois case. As the court in Rosenzweig observed, the opponent cannot sign his or her own opponent's petition And that would, because doing so would indicate support of an actual opponent in that case. And that also involved different political parties, which is a distinguishing factor in that case as well. The court did note and explain from the Citizens for John W. Moore Party, though, case, which is a Seventh Circuit opinion, the court in Rosenzweig talked about that what the candidate did there, and in Rosenzweig, the candidate literally signed the nominating position of her opponent and then decided to go and run as a different political party. And what the candidate did there is even more egregious example of a type of political maneuvering and the restrictions intend to prevent, that the restrictions intends to prevent, because she, the candidate there, signed the nominating petition of a candidate for the very office for which she intended to run, in effect supporting the nomination of her own opponent. And of course, like I said, Rosenzweig dealt with portions of the election code applicable to established political parties. Similar principles would apply here, but as previously stated, there is no evidence and no fact about signing petitions. This is all about circulation, people helping each other, and showing support for one another, but not in the overt ways that the election code says. And there is some difference too with how independent candidates should be running and nonpartisan candidates should be running. And ultimately, while it's difficult and while for whatever reason the candidate and the other candidates in these cases did this, ultimately the Illinois Constitution vests the authority of the General Assembly to ensure the secrecy of voting and integrity of the electoral process by passing of laws. And because there is no law that that the parties have cited to or that I'm aware of that explicitly prohibits the conduct here, and while the Electoral Board may not condone the candidate's actions and would gladly, if a court may disagree, but with the decision and with the ability to apply this, it is my opinion and my recommendation that the Electoral Board cannot grant the relief requested in the objector's petition, and therefore it would be my recommendation to grant the motion to dismiss and overrule the objector's petition. In this case.
So I have a question of the attorneys. Everything that the Attorney Ross Seckler said, do you have any response to that one way or the other?
No.
No, we understand. We understand the position. I appreciate Mr. Seckler laying out how in Article 7 this same sort of behavior would not be permissible. We understand that the statute as it reads currently, while allowing for an absurd result, reads how it reads, and we stand on our arguments.
Okay. Well, I find the whole process unusual. Other than that, I don't know how you legislate unusual. I think the voters have the right to decide if you get the correct number of nomination petitions in the election as to who they want to support and vote for. So I would move to dismiss.
Second.
Okay, motion to dismiss the case by Alderman Mike Seville, second Clerk Stallings. All in favor?
Aye.
Okay. Motion pass.
And just for the fullness of the record, then it would be a motion to overrule the objector's petition and find that the nomination papers are valid and find that the candidates shall be certified to the February 25th, 2025 consolidated primary election, or if one's not necessary, the April 1st, 2025 consolidated election.
So moved.
So, I didn't hear what you said.
Okay. Motion by Clerk Jennifer Stellings, second Alderman Mike Seville.
Second, yes.
Second
Yes.
Mike Seville, yeah, all in favor, say aye.
Aye.
Okay, pass.
So, on this case, I have a draft written up. I can send it to the clerk if you want to. It just probably needs a proofread. If you want to take it, we can go through the rest. On the other two, the one with the extended hearing doesn't have a decision yet because it's going to be an fact-based hearing. The second one, we hope to have by the end of that second hearing, that third hearing. But I would be happy to send this. It definitely needs a little review, but.
Yes.
And so the parties can, and John, you'll be here, but Ed, if you need to leave, if you're happy to email the final decision if we do it today, or I'll let, if we have to kick to one other day to finish the written decision, we'll also let you know. It's up to you.
Are you asking for a date then, or?
Yeah, if you want to come back for a date, or just in case, we're going to try to finish this. I have this one written. It just needs to be reviewed by the board and proofread a little bit. And we'll have other hearings.
I
while it's-
wouldn't come back for just the signing of the opinions.
Okay.
We can do that whenever.
Yeah, that's what I was asking. And so we can kick that to the very end, like we did prior to, and we'll all pick a date for all three of them if that works. Just in case. My hope is to have this one done today, though, if we can, just to.
Okay.
And my client is authorized to accept service of that.
Okay, very good. Okay, so in this case, that the board has voted, all that is needed to happen is to complete and finalize the written decision, which as required by the Illinois Election Code. That decision has to be signed and approved in final form in open session. As discussed with the parties, we will, I have a draft of that decision ready. We will endeavor to have that ready by the end, by the time the third hearing today is completed. If not, with the other cases, we'll need probably an additional date for those final hearings, as final decision entries anyways. So if not, this will be included in that as well. So if at this time would be a motion to recess case 24 AM OB03 and we'll proceed to case 2.
So moved.
Second.
Motion made by Alderman Mike Seville, second Clerk Jennifer Stellings. All in favor, say aye.
Aye.
Motion pass.
And so now we'll call case 24 AMOEB 02. That is Tara Loza versus Karina Garcia. Other parties present.
Good morning, John Fogarty for the objector.
Carrie Lynn Craftifer on behalf of the candidate.
Thank you. So in this case, we also, we heard the arguments mainly on the preliminary motions and any facts. We came back, and that was on the November 20th, and we continued for further argument, deliberations, and possible rendering of board decision today. At this time, the candidate, I did not receive this in email, but the candidates council did provide copies of the electoral board case that was cited.
I do also have the original affidavit, which was requested by the board, and I'll tender that to Mr. Seckler right now.
Perfect. So in this case, just to make everyone sure we're on the same page, there are 3 issues. One was an issue with respect to the candidate's name and use of name on her nomination papers. And the board voted at the prior hearing to grant the motion to strike those objections and found that the use of the name Karina Garcia is acceptable or in compliance with the law. The board just heard the dual circulation issue. It's the remaining issue, unless of course the parties want to put any other argument on the dual circulation issue, is with respect to the receipt of the statement of economic interest, and that the candidate in this case, whether the candidate filed a statement of economic interest in relation to the office sought. And so, unless the board has any preliminary questions with that, if the parties have any further argument.
I would just ask if the candidates' counsel could just maybe go through the relevant portion of the case that was tendered this morning, the Smith case, just the relevant portion relating to the statement of economic interest, if that's okay with counsel?
It is. I'd like a couple words on it as well, but
Okay.
absolutely.
Sure, so we have argued that, first of all, neither the Election Code nor the Illinois Governmental Ethics Act requires a candidate to place on their statement of economic interest the unit of government or the office. There's a standard form recommended in the Governmental Ethics Act, but it says that it has to be in substantially the following form. So there's not a requirement that the name or office be on the form. So with respect to this decision that I gave you, this is an opinion from the Chicago Board of Election Commissioners in the case of Hudson versus Smith. And if you look at paragraph 6 on page 2, it says the hearing officer further found that the omission of the office sought on the candidate's statement of economic interest was not a fatal defect, which would justify invalidating the nomination papers. And this case is from earlier in 2024. Now, the case that the objector has cited of Jones, there was an appellate court decision where the appellate court said, well, in this instance, the candidate has not filed a statement as an act in relation to candidacy because of those omissions. But that's distinguishable from this case because we have the affidavit of the client saying that this was filed as an act in relation to her candidacy. So that's the line in this decision that's pertinent.
Sorry. Did you file an affidavit?
It's attached to the motion to dismiss.
Okay.
Yes, and this is with regard to the Hudson v. Smith findings and decision you have just been tendered. A couple of things that are very important. And first, as we have argued, a decision by a fellow electoral board is not binding. An appellate court decision is. And the appellate court decision supports the objector here. More importantly, the Hudson v. Smith case involves a candidate for school board, the new school board districts that were up for election in Chicago. And the school code, it is argued by the candidate in this case, does not contain the in relation to his candidacy language that the candidate had to abide by in this case. So that is an important distinguishing factor. And then further, if if you read through the analysis and the recommendation of the hearing officer in the Hudson v. Smith case, which is adopted by the Electoral Board, it becomes clear that the issue in Hudson v. Smith was that the receipt did not contain the correct information for the office sought. The objection in this case is that the statement of economic interests filed by this candidate is not in relation to the office sought, because both on the statement itself and on the receipt, there is no indication of this office that is being sought. The Jones case, the appellate court case, is binding and should be followed, and it's on point factually as well. Thank you.
Any questions from the board? Any further arguments or issues to raise? So in this case, my recommendation with respect to the third issue about the dual circulation and the conduct of the candidates will be the same, and request that just be adopted and incorporated into the record for this case as well, instead of going through the whole thing again, if that pleases the board, unless you want to hear that again.
Do you need a motion to that effect?
Yeah, that would be appropriate.
I would move then to dismiss.
Or, move to adopt and incorporate the attorney recommendation from case 03 into case 02, and move to strike the objections related to the candidacy. I have paragraphs.
Russ, may I make just a quick statement before they do that?
Sure.
So the analysis of the previous case said the parties hadn't entered evidence, which is technically correct because it's still at a motion to dismiss stage. But what's distinguishable about this, and I just want to make sure this is in the record in the case of the appeal, the candidate does have an affidavit that was submitted in this case, which specifically addresses the issue about whether the candidates were working in concert with one another. So in paragraphs 23 through 29 of the candidate's affidavit, she specifically says she was not working in concert with other candidates to force a primary. So just to the extent that that nuance is subtly different than the statement that you made about the previous case, I just wanted to put that in the record for purposes of appeal. I don't know if I need to move to admit the affidavit at this stage, or because we didn't get to the the evidentiary portion, but that is in the record.
No objection to that. And to the extent that there needs to be a slightly different recommendation for this case, given that assertion, I think that's appropriate as well.
But in this case, the same circulators all circulated, right? It's the same issue.
Right, we
Yeah.
don't dispute any facts that could be deduced from the nomination papers in the record, but we also have an evidentiary statement, which you just represented in the last case, there was no evidence. So I just
Oh.
wanted to clarify the distinction for this case.
Understood.
No objection to that.
Okay.
So first, it'd be appropriate to adopt, to allow the candidate's affidavit to be admitted into evidence.
So moved.
Okay. Motion made by
Second.
Clerk Jennifer Stelling, second Alderman Mike Seville. All in favor, say aye.
Aye.
Okay.
Please.
And so, motion to adopt and incorporate the relevant portions of the attorney recommendation, notwithstanding the one piece of evidentiary distinction, or at least the piece of evidence that was introduced in this case, and adopt the ultimate recommendation and conclusions, and move to strike the paragraphs 9 through 17 of the objector's petition, I believe.
You need a motion?
Yes.
Mike? I need a motion. Okay.
Which, okay, can we clarify?
This is for the.
It's the economic.
No, this is for the dual circulation.
Oh, okay. If it's for the dual circulation, then I would move then to dismiss.
So moved.
Okay, motion made by Mike Seville. Second, Clerk Jennifer Stellings. All in favor, say aye.
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 Okay, motion adopt.
Okay, now it's the statement of economic interest. In this case, the facts are as follows, and we kind of laid out what the parties' arguments were the last time, but basically the issue here is that the candidate filed a statement of economic interest and a receipt that on its face says it's for a different, it says it's for the, as the, for CEO of the Aurora Regional Hispanic Chamber of Commerce. And the filings, the actual statement of economic interest says the same thing, also noting that the candidate used a different name on the statement of economic interest, did not use her ballot name. But that's, that issue is put aside. The issue here is that 10-5 of the election code says that a candidate is not, nomination papers are not valid if a statement of economic interest and the relevant receipt is not filed in relation to the candidacy sought. The case of Jones versus Municipal Officers Electoral Board is almost directly on point in this case. That case, as we discussed last time, the candidate filed the statement with the county clerk and wrote his name as Reverend Elias J. Jones, 3rd Ward, and then office or position of employment for which the statement is filed, he wrote pastor of First Unity Missionary Baptist Church. And I believe that same thing happened, was shown on the receipt.
Say that again.
The same information was shown on the receipt form. So he filed, and it said he was filing for the pastor of the First Unity Missionary Baptist Church. He was filing for a position of alderman, not for being CEO or pastor or anything like that. In that case, the court found and held that the filing was invalid, that you are required it is a mandatory provision, and the election code and the Illinois Governmental Ethics Act have to be read together, and that the failure to state and explain that this was for the office sought, the actual office sought, is fatal, because how are people supposed to know, be able to look up your economic disclosure? That's the whole purpose. This statute is very, it seems strict, but it is strict for a purpose. It's because we require people to comply with these basic things in order to be considered a candidate. And they're not, again, the election code says the papers are explicitly not valid unless if the candidate fails to file a statement of economic interest in relation to the office sought. Here, the uncontested facts before us show that the candidate filed a statement of economic interest and says it was for that on its face says it was for her position as CEO of the Chamber of Commerce. The receipt says the same thing. The candidate, frankly, seems to have admitted that was a mistake by filing a new statement of economic interest and a new receipt after the filing period that says it's in relation to the office of mayor. So it's almost further showing that she knew that what she did right first time was incorrect and invalid, and then establishing that trying to fix it, but the code explicitly says you have to file that within the filing period. And it's so that you can't just get away with that if an objection is filed against you. You have to do it. Once you're caught on it, it doesn't mean you can go and fix it. You have to comply from the first part. And so while it may seem like a grave result, I would recommend denying the motion to strike the objection with respect to the statement of economic interest and granting sustaining the objection with respect to that.
Wait a minute. If you deny the motion to dismiss, the motion is denied. That would mean we would have an evidentiary hearing on the underlying issue in the complaint. There's not a cross motion for summary judgment that's been filed, and I have evidence to put on. So we'd have to schedule a hearing on that issue.
So, Ms. Krafteffer, there have been 2 other hearings for this where I've asked for the parties to either stipulate or provide evidence. You've just provided one affidavit.
Right. We did not
So-
work out a stipulation, but I have 3 witnesses here today if we want to proceed to an evidentiary hearing. However, this was not set for an underlying hearing today, so I have not disclosed my witnesses or evidence to Mr. Fogarty under Rule 5. If he'll waive that, we'll proceed to a hearing, but I have evidence and testimony to put on that underlying issue. He has not filed a motion for summary judgment, a motion to dismiss. Under the rules, we're entitled to an evidentiary hearing. We're only here on my motion to dismiss.
What?
And if I may, this is a legal issue. The legal issues have been briefed. I don't know that there is any contention of fact that could possibly even be raised that would be relevant over and above what is in the record before you in the motion to dismiss.
That's my issue. Yeah.
No, I have the ability to defend the objection. This is not set for a hearing on that today. I have the ability to make my record, and I believe that the issue of whether or not she filed a statement as an act in relation to her candidacy isn't a matter of law, it's a factual issue. So I will present evidence from the candidate. I present evidence from someone who submitted a FOIA request to the Kane County Clerk seeking information related to all candidates for mayor that have in Aurora that have filed economic interests, who will come forward and say that they received actually her original statement of economic interest that she filed with the other name on it. So it was clear that the county clerk believed it to be an act in relation to her candidacy, and the information was provided in response to that. And then I also have the attorney here who handled the Hudson versus Smith case, who would testify that the underlying issue in that case was the failure to put the candidate's office and position on the statement of economic interest, not just on the receipt. So, I mean, I would, if you want to stipulate that they would testify to those things if put on, but he has not presented his case yet. It's his burden of proof.
Well, it is his burden. It's the objector's burden of proof. But this was agreed as a legal issue. You guys came in last time and said that there were no issues of fact. You said that.
Related to the motion to dismiss, not the underlying objections.
We're here for, it was set initially on November 8th for a hearing on motion to dismiss and on preliminary motions, and then any further arguments. Then we set it for today for any further arguments in hearing.
Okay, and we can have, once you rule on the motion to dismiss, procedurally, he has the burden to prove his underlying case. He has not submitted any evidence in respect to that. I have my evidence here today. I'm ready to proceed on that. It's not in the case management order that's what was to happen today. But your recommendation for a ruling on my motion to dismiss was to make a factual finding related to the underlying matter, which isn't before the board on the motion to dismiss.
Well, the factual findings are what were agreed and what are in the record, are what on the face of the documents are. That's it. There are no other facts at issue.
Well, I disagree to that. I believe there are facts at issue. That's what I thought the underlying hearing would be for if we got to that.
And you have not disclosed any evidence.
Because this wasn't set for that hearing today.
Excuse me, it was.
Not if you look at the case management order.
That was the
And
first
if-
case management order, and for the record.
If I may, so
Yes.
our position is all of the things that have been spoken of, the additional so-called factual evidence, it is not relevant. If it were pertinent to the motion to dismiss, it should have, or if it was pertinent to this case, easily could have been included in the motion to dismiss. This is a legal issue, and you have everything that you need before you to make the decision in this case.
I would just clarify that I did disclose witnesses to Mr. Fogarty 48 hours prior to the last continuance date. But I did subsequently become aware of other witnesses with respect to other things. Now, if the board is going to deny us of our ability, even though we believe there's a factual issue in dispute, to put on factual evidence, you can do that. I'm just preserving this for appeal.
Any questions from the board? So the issue here is that the candidate's attorney has now, at the last hour, despite what was said at the last hearing, and there was no subsequent case management order. The case management order was for briefings after November 8th, for the record. It was stated that this matter would become here for final arguments and any further hearing to be necessary and to be done. The candidate now wants to put on evidence and has witnesses apparently that are undisclosed and otherwise untendered that will talk about, as she says, I guess, which she alleges as being factual issues in this case. The objector opposes that, given that, and says that the case is based on the briefings and the filings is on its face. That's what the case is. I mean, that's really the scope. It's up to, if the board wants to entertain that or allow them to put on offers of proof at the very minimum, that's up to the board. If not, the board can do, you are all able to do as you please.
How would we get any more information from the attorney who argued the case than we would get from the record?
That I wouldn't recommend allowing.
Okay. Okay.
You wouldn't what?
Recommend allowing an attorney from another case to talk about a case that is non-precedential.
Okay.
There's no, I guess if you tried to qualify him as an expert, which is irrelevant to the case that's also undisclosed, makes no sense.
And how would we get any more information from the candidate as to, would the candidate's intent be relevant, more relevant than the actual, the physical record of what we have from the county clerk? If the candidate were allowed to testify? I guess that I would be confused a little bit.
Right, and that's part of the problem. In my opinion, I don't know if there would be any relevance to any of that. You can intend to do many great things, but because you didn't do it, you didn't comply on its face, is a different issue. And so, again, it's up to the board if you want to entertain that or allow her, on those bases, to put in anything she wants into anything like that into the record. That's a different issue, but I don't know what the relevance, honestly, what the real relevance here to the case at hand and to the actual issues at hand.
And then finally for counsel, if, did you say you have someone here from the Kane County Clerk's Office? Oh, you said you had someone here who submitted a FOIA request to the Kane County Clerk's Office who received a response to their FOIA request regarding, okay. Okay. Okay, that was just my last question.
So I guess it would be appropriate for a motion to allow the circumvention of the rules and to allow the candidate to put on her proposed evidence at this time.
For the record, and I just want to make our record here.
Yeah.
We would oppose such a motion. We did speak about stipulations, but if any of this, I mean, these particulars are new, and they were not offered in any way. I need time, if there's going to be an evidentiary hearing, to have items properly disclosed and scheduled. So I'm not waiving Rule 5, and again, we think this is irrelevant anyway, but I do not waive Rule 5. It will not happen today.
Well, and the board is in the middle of ruling on a motion to dismiss. If I prevail on the motion to dismiss, there doesn't have to be an evidentiary hearing. So procedurally, the board needs to rule on that and then decide what it's doing on the underlying case. But as I pointed out, Mr. Fogarty has not made a motion for summary judgment on that, and the stipulation would only agree to facts that were undisputed, not disputed facts, so that's where the evidentiary hearing would come in. So I think the board needs to determine what it's doing on the motion to dismiss first, and then we would decide whether there needs to be an evidentiary hearing on the underlying objections.
Fine. So it would still be my recommendation that the board move to strike, or move to deny the motion to strike the issues regarding the statement of economic interest. I believe that is paragraph 8 of the objector's petition. And this is just the motion to strike or dismiss, then notwithstanding any future evidence or facts, like I said.
So moved.
Rose, can you repeat that motion again, please?
Repeat the motion.
Motion to deny, just the motion to strike paragraph 8 of the objector's petition regarding the statement of economic interest.
Okay, and in...
It is not to grant the objection at this time, just
Okay,
yet.
meaning that...
Meaning that we would proceed on that issue.
Okay.
Alone, that issue remains.
Okay. And Alderman Seville moved. Second?
Okay. Yeah, made by Alderman Mike Seville and second by Claire Stellings. All in favor, say aye.
Aye.
Okay. Motion adopt.
Okay, so now we have to proceed on that objection itself. And that's where we get into what was previously discussed regarding whether there is a need for any further evidence or anything else. The briefings of the parties so far have laid out the legal issues at hand. In my opinion, this is a legal issue. This matter was, again, set for any and all further arguments and hearings for today. Neither party has disclosed any further evidence or any desire to proceed on any further evidence, notwithstanding any determination with respect to the motion to strike and dismiss. And so the candidate is requesting an ability to put on evidence now, despite that, and the objector opposes that. Anything else from the parties on this with this respect?
Yes, I'm not just requesting to put on evidence. The burden of proof is on the objector. The objector has to prove his case. So I don't believe the issue of whether or not a statement of candidacy was filed as an act in relation to candidacy is a legal issue. I believe it's a factual issue. Now, the board can find it's a legal issue, but the first thing would have to happen is Mr. Fogarty has to put on his case. If he puts on sufficient evidence, then it would come to me to put on my defense with my witnesses that are here. And we're prepared to do that today, if necessary. Mr. Fogarty requested time.
So this is a legal issue that can be decided on the facts that are in your possession. The records that are in your possession that have been appended to the motion of the candidate. And so I think you have all that you need in order to rule on this issue.
Yeah, in this case, the candidate did append many documents and other information. The board has its own exhibits that we've already moved into evidence, which on their face show what, those are facts that, you know, the candidate is right with that respect. Yes, this is factual with respect to what do the documents say, and what are those circumstances. But those are also uncontested facts at this point. They say what they say. They're in the board's records. The candidate attached the full statement of economic interest in her own motion to dismiss, the statement of economic interest at issue, that says it was filed by Karina Y. Garcia Alanis, and for job title CEO, Regional Hispanic Chamber of Commerce, and King County Clerk. That was, and that's what that says. That's what the receipt similarly says. That's, you know, my prior recommendations in legal analysis versus with respect to the binding precedent for this board in the Jones case, is, you know, notwithstanding the issue with the Chicago Electoral Board, and not to, you know, that the issue with the Chicago Electoral Board's decision is that it's an electoral board decision, just like a court or other board doesn't have to follow your decision here, but we have to follow court decision. So we're kind of bound by binding precedent, not an electoral board. And there are distinguishing issues, I believe, here, it seems, with respect to the school code versus in the nature of that electoral system. So again, the candidate is requesting that we open up proofs and evidence and allow them to put on, make issues of fact. The objector is objecting to that. And the candidate is also saying that it's not it wouldn't be them to go first, but the objector's case based on the filings are, you know, the objector is welcome, I guess, would be welcome to make further argument, you know, do whatever they want. But if we want to open up to this, to further evidence and proofs, that's up to the board.
So at the end of the last hearing, I did mention to the candidates council that I was hoping that there would be some precedent that we could see or read, or hoping that there was some evidence that we could see, and I was hoping that we would have that today. So the case that we have, while I believe that's what you were referring to, counsel, at the last hearing, it doesn't seem to be binding, and I was really hoping it would be, because again, I want to see everybody get on the ballot that can. I did take time to read the cases. I took time to analyze them and the statute, and I mean, at this point, it just seems that everything, it seems very clear that according to the case law and the statute, I just don't see that we have any choice, even on the face of what we have in the pleadings. I don't know what else could be presented to us that would make any difference. I just don't know what else there could be. So I've been trying to think of something and hoping that there would be something, but based on all of that, I don't know that there would be anything else. So as far as where we would go from here, Mr. Seckler, I'm not sure.
Right, that's my.
Okay.
I don't know what relevance the purported and proposed evidence could be to this case, other than, frankly, wasting time. or muddying a record and trying to make some sort of argument, but that is ultimately irrelevant to it. At the same time, we try to make these records and these cases full and complete as much as possible to, because knowing that if a reviewing court wants to be able to find and see exactly what happened and have a full picture of what happened. But at the same time, we have a duty and pursuant to the rules to not allow for totally irrelevant or confusing evidence, essentially. That would, and to the extent that none of the evidence was disclosed or otherwise even proffered in advance, and unlike the next case we'll get to where it was disclosed, the board was able to see that in advance. We have that ready to go. We're ready for a continued and long hearing. That's not this case. So, if the board really has two options, I guess, or three. One, it could deny the request to put on further evidence by the candidate and take the case as presented in the briefings and filings and what we do have. It could allow the immediate calling of witnesses and putting on any evidence that I guess either party has, or it could set this for another hearing date for allow any sort of evidentiary hearing where the parties would disclose that evidence. Again, it's whatever the board wants to do. I don't know what relevance that evidence would be other than, but that is, if the board wanted to entertain that, just to allow them to do that, that would be up to the board.
Is there any precedent or case law based on that?
On which?
Allowing more?
There's the precedent in case law says the board has its rules and can enforce and is entitled to enforce its rules and enforce its rulings. And so if parties don't comply with those rules, or if they're offering evidence that is irrelevant in violation of those rules, then the board is allowed to enforce its rules against those parties and has wide discretion to do that.
I just want to clarify, though, I'm not asking the board to allow me to put on additional evidence. I'm asking the board to require Mr. Fogarty to prove his case. And when he does that, then I would put in my evidence in response to that. This is just before you on a motion to dismiss. So these repeated statements that I'm violating the rules, I'm not violating any rules here. The rules are that Mr. Fogarty has to prove his case. If the motion is denied, he has to do that. If he doesn't want to put in anything further and he's resting on his arguments from the motion to dismiss, he can do that. But I don't think anyone said that I have to put on my complete defense to my case in my motion to dismiss that I filed.
So they just voted to deny your motion with respect to this.
So now,
Right.
so the motion is denied.
Yes.
He now has to present his case.
And he indicated that his case, unless I'm wrong, that it would be based on the board's records and the prior filings, including the exhibits attached to the candidate's motion.
Exactly, that's
He
right.
just said that, so.
Okay, so you're resting on the pleadings that were submitted in response to the motion to dismiss. That's you're resting on your case there.
My case, this is a legal issue that has been briefed. The board has before it the receipt filed by your client, the statement filed by your client. They have everything that they need that is relevant to make their ruling, their legal ruling on this issue.
Then I would respond by saying I would move to admit the candidate's affidavit that is attached to our motion to dismiss as evidence.
So that was already moved into evidence.
Okay, thank you. Then I would make a motion for a directed finding, because the only factual evidence before the board related to, and we dispute whether or not it's a legal or factual issue, but I just want to make this record, okay? The issue of whether or not the candidate filed an act and statement or statement of candidacy as an act in relation to her candidacy, I believe is a factual issue. And in the record, based in the exhibit I submitted, the only evidence you have before you is a sworn statement of the candidate that she filed the statement as an act in relation to her candidacy, and that that was the only reason she would have for filing a statement of economic interest. So I would make a motion for a directed finding at the conclusion of his proofs that the objection be denied.
Okay. So the candidate has moved for a directed finding, meaning that she believes that after all the evidence, that the evidence in the record, which the objector has asserted is the entirety of his case, and all the prior briefings and the arguments that we've already discussed, that she was entitled to a judgment as a matter of law based on the record and facts before you, that the objection should be overruled and that she should be on the ballot. I do not recommend granting this objection, this motion, as the facts before you show that that is not the case. That the case is that the candidate filed a statement of economic interest, it seems, in relation to, its, as it says on its face, CEO of the Chamber of Commerce. And so, and that's what the receipt and the statement both say. That is what was filed, what's presented to the city clerk's office, to the voters. And then she made it, the only extra evidence really is her her subsequent filing, which is not a legal filing for candidacy purposes, but it basically an admission of that she made a mistake on the first one, and did the first one incorrectly. So with a directive finding would mean that the candidate doesn't have to put on any evidence or case anyways. In this case, because the candidate asserts that she has evidence and facts, in either event, it wouldn't be, it would not be appropriate at this time, at least in my opinion. Of course, you are the board that votes.
So it sounds like what you're saying is it's your recommendation that the board denied the motion for a directed finding.
That's my recommendation, yes.
I would move as such.
Second.
Okay. Motion made by Alderman Mike Seville, second Claire Stallings. All in favor say aye.
Aye.
Okay.
Aye.
Motion accepted.
Very good. Okay, so now we're at, and so we have this full record so far that the candidate has, despite this being legal issues, wants these to be factual issues. And so we have facts before us, and they're at this point uncontested, other than apparently what the candidate is asserting. There are some contested facts. But again, now it would be allowed, whether or not, I guess if the candidate wants to start, you can make any further argument, and then we can move and see if it's appropriate to allow the presentation of any further evidence or proffering evidence. But again, it wasn't disclosed or anything else, so
So the objector, I'll speak to that. You mentioned the candidate. So, but if you're asking for are you asking for my commentary?
no, I was more just laying out where we're at. Just
Okay.
that at this point, because the candidate is insisted to, whether she wants to put on evidence and has witnesses, et cetera, the board will have to decide if that's in order and if that's going to be allowed under our rules. And so, and that's really, it's whether or not, I guess, as it was discussed prior, whether it's appropriate now for a motion to open proofs and to allow the evidentiary hearing to proceed despite there being no evidentiary disclosures or anything like that. You know, if the I guess, candidate, if you have anything else you want to say with that respect, I know, you know, I think the board has your positions on this issue. If you want to say anything else about how you want to proceed.
No, I believe the board's rules would allow me to put on evidence as a defense. And I think that's different than advocating a motion to dismiss.
Well, the board's rules also have disclosure requirements, and they've not been met. So we don't think that just putting on extra evidence, especially that's not relevant. I mean, we're trying to put on evidence to now contradict something that's been filed and on file for a month and a half. It's just not an appropriate exercise that you need to entertain.
Does the board have any questions? Okay, so there's, like, as I said before, there's three general options here. The first is to deny the candidate's request to put on further evidence in this case, citing one, whether or not the proposed evidence, not the relevance of that evidence, and two, that there were no evidentiary disclosures made at all from either party in this case in any way, shape, or form. And so, you know, despite having requested that and being clear in the last hearing, at least I thought, and I thought the board was clear in that regard, that this would be the final hearing in this case for everything. And so despite that, there was no disclosure. So the first option is to deny the candidate's request to proceed with further witnesses and any evidence that has previously been undisclosed. The second option is to allow the candidate to proceed immediately with any evidence that she has here, with witnesses, et cetera, that have not been disclosed or otherwise. And the third would be to continue this matter for another hearing date to allow the parties to disclose any evidence, et cetera, and then hear any relevant evidence, again, assuming that there is any relevant evidence in the first place. So those are really the three options, whatever the board.
So if the board were to allow further evidence, that could proceed, both parties agree that could proceed now?
We do not. We do not agree. So there have been no disclosures. I will need to, depending on who is disclosed or what is disclosed, I need notice of that before proceeding. The case you have after this one, we received disclosures on Friday night, so I had the weekend to prepare for 37 witnesses anticipated, potentially. So that's what is called for in the rules, and to the extent that you're even contemplating asking for additional material, it needs to be disclosed. So I don't waive Rule 5.
What if we were to allow counsel to give an offer of proof of some sort orally, a very fast offer of proof, and then, I mean, just as an option? And would we then be able to determine whether or not we wanted to proceed further? Or would that make for a terrible record?
No, that would be, that would,
Well, I mean, that would be acceptable today. Typically, an offer of proof would come after denying the right of someone to put on the evidence.
I guess I'm just torn between punishing a candidate and whatever the other side is. You know what I mean? That's all. So if that is a viable option, that would be my,
It would be appropriate if the candidate could make an offer approved, and the candidate's counsel, through counsel, would make an offer approved, and then the board could determine if that was even relevant to its understanding or proceeding, and if it wanted to really investigate more, the board has some discretion to open up those hearings just to see if it's even relevant, so.
if we are able to determine from the offer of proof that we would not find that further evidence would be relevant, are we able then to deny further
Yes.
evidence?
Yes.
Okay. That would be my choice.
Do you want me to just make an oral offer of proof then?
Yeah, that would be perfect.
Okay, I would be calling the candidate Karina Garcia. What she would testify to is that the initial statement that she filed on October 26th was filed as an act in relation to her candidacy. There was no other reason for her to file that. The subsequent disclosure that she filed was not because she felt like she made a mistake on her original filing, but that it was because although neither the election code nor the Governmental Ethics Act requires the candidate to write on the statement of economic interest disclosure either the unit of local government or the office, that she did that after receiving the objection because it was apparent that other people believed that that was what the law required. I would also call John Lesh. He would testify that he filed a Freedom of Information Act request with the Kane County Clerk's Office for all candidates for mayor in the city of Aurora, and that in response to that request from Kane County, what he received was the original October 26th Statement of Economic Interest filed by Karina Garcia. What that demonstrates is that the purpose, the letter of the law, and the spirit of the Governmental Ethics Act were all complied with, because if you have that law, because people need to be able to know the statement of financial interest that a candidate has with respect to a unit of local government. In this instance, he received it in response to that request. So it was clear to the Kane County clerk that people who are seeking information on candidates for mayor would receive that. Now, the board can say that's irrelevant, but that's relevant because it actually shows that the Governmental Ethics Act was complied with. And then finally, I would call Mr. Kevin Morphew. I would not call him as an expert witness, but I would call him because the representation here was that the Hudson versus Smith case only applied to the office missing on the receipt. He would testify that he was an attorney in that case and that the issue was whether or not the underlying statement of economic interest bore the unit of government or the office at all, and he would testify that it does not. So that would be my offer of proof, and I believe all of those things are very relevant.
Any response?
Obviously, we contend that is none of that is relevant. What's on the four corners of the documents that are in the record are what is relevant. In the spirit of moving this along, I have no issue with, yes, that is the position of the candidate's counsel. I would ask that you disregard certain statements with regard to, obviously the Kane County clerk knew XYZ. I mean, that's obviously not proof, that is more argument. But again, not any of this is relevant. You cannot run an election system where someone can file something by the deadline and then go on and correct it after the fact. Corrected once after the fact with an additional filing, now attempted to be corrected again with affidavits, with live testimony. There would be no stop disagreements over who may be on the ballot if you permit such irrelevant information to come in here and in other cases. So I understand the offer of proof. You've heard my statement on it, and that's that. Thank you.
Thank you both. So in this case, I guess the request one is whether to allow this evidence to even come in or whether even to proceed on it. That the candidate has made an offer of proof with respect to the 3 issues she wants to raise. You know, if the law is here that the candidate has to file a receipt and statement of economic interest in relation to the office sought. The candidate wants to make that a question of intent and underlying circumstances regarding how she filed or why she filed the statement. Whereas the law, at least with Jones versus Municipal Officers Electoral Board, says that that's part of it, I suppose, but it's really what it says on the statement itself. What you write on the statement is what office is this filed in relation to, and that's a binding appellate court decision that hasn't been overturned or anything like that. It's been distinguished in different ways that don't apply here. So that's really where we're at, is the board can entertain the candidate's request to proceed with further evidence as you know, in the manner she described, or we can just close the evidence and you know, the board can still deliberate based on what the record is before us and what the issues really are.
I think while I appreciate the offer of proof, I think it was very well summarized. Thank you very much. I personally, I don't think that it negates what the letter of the law says and what the case law says. So I don't think that we can take the evidence as presented into consideration. So however we have to do that, Mr. Seckler, unfortunately, I think that we do. However we have to word that.
So I think it would be appropriate for the record to make a motion to deny the candidate's request to put on further evidence, despite the offer of proof and evidence that was not disclosed or otherwise, and not allow that to proceed at this time, and to take the case on the record and arguments before it.
So moved.
Yeah.
Second.
Okay. Motion made by Jennifer Stellings, second Alderman Mike Seville. All in favor say aye.
Aye.
Okay, motion pass.
Okay. And so now it would be appropriate for any further questions from the board or any further deliberations into rendering a decision on the issue of whether the candidate, the issue as raised in paragraph 8, I believe, of the objector's petition concerning whether the candidate filed a statement of economic interest, whether the candidate properly complied with section 10-5 of the election code and filed a statement of economic interest in relation to the office sought, where the statement of economic interest and the receipt says that it's in relation to the being CEO of the Aurora Regional Hispanic Chamber of Commerce. And for the previously stated reasons and based on record and case law, the board's own records, the records attached to the candidate's own motion to dismiss, I cannot, and as I said before, it seems harsh and understandably so. This is, it's one where the law does not allow any leeway here. That, I mean, the case law, the Jones case is directly on point, where the person even wrote third ward on the statement of economic interest form, and the appellate court still says you have to file, but then he wrote pastor of First Unity Missionary Baptist Church. So it very similar in that this person filed their statement of economic interest in relation to, or it seems to, a private entity, and that's what she wrote in both the statement and on the receipt. And because of that, it's not considered on its face in relation to the office sought as required by law, and therefore the candidate's nomination papers, according to the mandatory provisions of Section 10-5 of the Election Code, must be rendered invalid. And the objector's petition, paragraph 8 of the objector's petition, should be sustained.
I know this is on the record, but I don't think any of us want to do it, but so moved. I did.
I'll second the motion.
Motion made by Jennifer Stelling, second Alderman Mike Seville. All in favor say aye.
Aye.
Motion
Aye.
pass.
Okay, so we will need to issue a written decision on this, pursuant to the Illinois Election Code. Final version of this, given that the proceedings of today need to greatly supplement and change what we've done. So what has been pre-prepared. So we will need to pick another date. We can do that theoretically at the end. That will only be for the signing and rendering of the decision in open session, as is required by the Election Code. Council are welcome to be here. It's an open proceeding, but need not be here if needed.
I will waive the candidate's ability to be served in open session as required by the code, provided the electoral board attorney just sends me by email the decision.
Send it by email immediately when I get back to the office after. Okay. And then we'll pick a date at the end of the next one. If that,
Any rough idea what the time period will be?
we, either before or on December 3rd, we have, the other cases are up December 3rd. Hopefully we can just do it before, though. The other cases are up then, but we should be able to get these done before. December 3rd would be the absolute last day, because we would just do it all at the same time, but these should be done sooner.
December 3, we have a 4:30, right?
Yeah.
So we have enough time?
That's plenty of time, but we can even come back sooner.
Okay. Because committee of the whole is start at 5. The committee of the whole is start at 5,
Okay,
so we have half hour.
yeah.
Okay.
Those will all be for just signing and issuing the final decisions. They've all been voted upon.
Okay.
And we just need, the code makes us put a written decision together, and then we sign and issue it in open session.
Okay.
Okay. So with that, we'll, unless the board wants to pick a date now, but we can maybe pick one at the end of the next one, either way.
Pick at the end of the next one.
Okay. So then we'll move to have this matter in recess to be, for a future date to be set after the end of the hearing of the case 01.
Thank you.
Thank you.
Thank you.
Do you guys want a quick break or anything before we go on to the next? The next one's gonna be a little bit longer.
Mhm. Yeah.
We're gonna take a quick break before the next one, because the next one's gonna be a little bit longer, so.
Jennifer Stelling?
Here, or what?
Yes.
Yeah.
Are we doing? Yes.
Roll call. yeah.
Oh, yes,
Yeah,
here,
roll.
sorry, I didn't hear you.
Yeah. Alderman Mike Seville?
Present.
Okay, and myself, Juani Garza. And best to the council.
Thank you. First, we're actually going to go back quickly to Tara Loza versus John Leish, 24 AMO EB 03. I know counsel for candidates said he had to go, and counsel for objector is here. For the record, in the meantime, we were able to finalize the proposed written drafted decision and are able to issue that here today. So I have prepared those. They reflect the board's arguments and the arguments prepared by the parties, which were done by all three cases, and reflect the board's decision, finding that the electoral board overrules the objector's petition and finds that the candidate's nomination papers are valid. In accordance with the Illinois Election Code, as stated prior, a written decision is required by the board, and a motion to approve and execute those decisions are required to be made in open session pursuant to the Illinois Open Meetings Act. So I would request a motion to adopt and approve the proposed findings and decision of the electoral board in case 24 AMOEB 03.
So moved.
Second.
Motion made by Clerk Stelling, second Alderman Mike Seville. All in favor, say aye.
Aye.
Motion passes.
So if you're able to, we'll have these executed now in open session. We'll have each copies. Copy will be tendered to the counsel for the objector. Candidate, if candidate's attorney indicated that the candidate can accept service directly, as he's present, or and I frankly will just email a copy to the council of record as well for their own records once we're done with all the hearings for today. So again, this is just the execution of the final written decision and terminating case 03. So, Mr. Fogarty, if you approach. For the record, I'm providing a copy to Mr. Fogarty, counsel for the objectors in case 24 AMOB 03. And Mr. Leish, if you want to approach, or I'm happy to just email to your counsel. To Mr. Leish, wow. If you want your copy, your attorney said you could accept it. Thanks. For the record, I've tendered it to the candidate himself. We have an original for the electoral board as well as, and then I will scan and send out the executed version to council of record as well. And that will so we'll need a motion to adjourn case 3. Case 24 AMOB 03, AMOEB 03.
So moved.
Second.
Motion made by Alderman Mike Seville, second Clerk Stelling. All in favor, say aye.
Aye.
Motion passes.
Okay, that case is terminated. Now we'll move on to case 01, which is call the docket of Tara Loza versus Jasmine Garcia, electoral board case number 24 AM OEB 01. Are the parties present and accounted for?
On behalf of candidate Kevin Morphew.
And John Fogarty for the objectors.
Thank you both. In this case, when we last met, we set this matter for further hearing and for evidentiary hearing, and for further deliberation on the dual circulation issue. Dual circulation, quote-unquote, political party, whether have you issue. And then for record of evidentiary hearing regarding the records examination. The candidate did file, both parties filed motions pursuant to Rule 8 of the Rules of Procedure contesting individual results of the records examination. The candidate filed timely evidentiary disclosures with respect to what the candidate intends to introduce today at hearing, as well as there's one additional evidentiary disclosure that was also timely made, but just done separately in a separate PDF. That was served and that was also provided to the Electoral Board in advance. So today first, I think it would be appropriate to deal with the dual circulation issue, and I believe that's paragraphs 12 through 19 of the objector's petition. Is that correct, Mr. Fogarty or Mr. Murphy?
That's correct.
Okay. So I would request, unless the board wants to hear it all again from the first time we read it, I would request that you adopt my recommendation in case 1 and restate it as the recommendation for case that was in case 3 and restate it in case 1. In that I recommend ultimately that the board grant the motion to strike paragraphs 12 through 19 of the objector's petition and overrule those objections in paragraphs 12 through 19, which is the dual circulation issue.
So moved.
Second.
Motion made by Alderman McSibil, second Clerk Stellings. All in favor say aye.
Aye.
Motion passed.
Very good. So now we proceed. After following the records examination in this matter, the candidate's nomination papers were shown to have 524 presumptively valid signatures, which is 17 signatures below the statutory minimum of 542. Is that
I believe it's 525 valid
525?
on the objection summary report tendered to the parties as the final report.
Yeah,
We'll take 524.
My apologies. I wrote 525 is what was correct. Yes.
And then the, I guess we could call it the amended objection summary report to reflect the required signatures at 542.
Yes.
Reflecting that the over-under required is -17.
Correct.
Yes.
That's
Correct.
Agreement. Okay. So the board knows that's where we're at. We have 525 presumptively valid signatures. You need 542, and so pursuant to the rules, the candidate would then be able to proceed with their motion pursuant to Rule 8 and their arguments, presentation of evidence, and going through. I think we have it set up, Clerk Stallings, that we can display things here. And we do have the original nomination papers here for the board.
And then just for anyone else who's doing any videotaping in the room, we will be displaying candidate signatures and then county clerk certifications, which do contain personal and private information of the people who actually signed the petitions. So if you can please not record and or disseminate that personal and private information, that would be greatly appreciated. We're also asking our people here who are, they are people who are putting this on YouTube for us, not to put that information on YouTube. They will not be focusing on the screens. When we are showing the screens, they will be focusing on all of you, hopefully not so much us up here.
Just, you know, the Open Meetings Act allows, of course, recording. We're not having, unless we have live witnesses, and we have to limit recording for those people for their comfort. But we just, as a request, to not have private information so publicly available. If as the members of the public and the parties with it so accommodate. Thank you. So with that, I guess, candidate, if you'd like to proceed.
Sure.
However you'd like
Here
to.
on the candidate's Rule 8 motion, Madam Chair, I do, and Mr. Seckler, I do have the original affidavits that I will be seeking to submit for pretty much each affidavit that I am submitting, there's an attachment of the signature, the candidate's petition sheet that was signed by the voter, which has been moved into evidence as an exhibit, Mr. Seckler?
Yeah, the entire,
And-
that's,
And accompanied with the voter records that the relevant election authorities were able to locate on that particular voter. So would you like me to tender all these, and then Mr. Fogarty and I each have copies? We can just go
that would be fine.
that way?
yes. Thank you.
And then something's just let me know.
Okay. And I guess if the board wants to, I mean, you all have the digital copies if you want to see the originals, or you can move, whatever, however you guys want to do it, that makes it easier to see, but you let me know.
Okay, so if you don't want to see the originals, I will display what I have on the monitors, so they should be showing up on your monitors once we know what specific items we're talking about.
Okay.
And if
Okay.
Mr. Fogarty would like to inspect them as originals.
If necessary. I don't see a need right now.
Sure. Okay. The first line we are seeking to rehabilitate is sheet 1, line 6 of the objector's petition. The ruling at the records examination as to signature.genuine, not signed by proper person, was sustained. I present the affidavit of Derek McCurdy, who states under oath that he signed the candidate's sheet 1, line 6. His signature appears on the affidavit. It is a direct match of sheet 1, line 6, his signature. And if you turn to the voter record for further exemplar, the signature shows Derek McCurdy, who is registered to vote at 149 South Gladstone Avenue in Aurora, Illinois. And the signature exemplar, which was with the election authority, was from 2010, shows that the D and the M of his first name is a match to how he signed his name on the petition. And we ask that this signature that was sustained be overruled.
And in response, the objector offers that the facsimile signature of the voter on the on the certification provided by Kane County is not a sufficient match to what is on the as to what is on the petition sheet, and our contention would further be that the affidavit provided by Mr. McCurdy, while yes, it matches the petition sheet, it does not sufficiently match the certification, which is, I think, what is key in this case, or in this instance.
Okay, so,
And if I may, what's key in this instance is that the voter who signed the sheet is swearing that they are that person and that they did sign that sheet. And that's the compelling evidence. The certification from the clerk's office just seeks to bolster that proof, because the D and the M are similar, and it shows that the affidavits established that he meant to mark his name there, that is his signature, and he is the registered voter, and that he would like for his name to count towards the candidate's signature tally.
And the issue with that argument is that the affidavit does not explain why the difference between what is on the petition sheet and what is set forth in Kane County's records. And for that reason, we think that the affidavit is not sufficient counter evidence to outweigh the prima facie evidence that has been rendered by the records examiner. With regard to affidavits that seek to rehabilitate signatures, Our contention is that the rule enunciated in Fritchie v. Romanelli, which is again, a Chicago board case, so it's not binding upon you, but it stands for the proposition, among other things, that while an affidavit may be offered as evidence to try to rehabilitate a signature, without an explanation of what the difference is between the signature on the petition and what is on the voter's record, that affidavit is just not sufficient. And I'll tender Fritchie v. Romanelli if you would like. I'll tender to council. Again, while this was a Chicago Board of Elections decision, it was appealed up to the appellate court, First District, and I'll attach that order as well. No opinion was rendered in that case, but the appellate court essentially agreed with the findings and decision of the Chicago Electoral Board that an affidavit does need to do more than just say, that's my signature. It needs to explain why the difference. I mean, why are you now changing, or why are you now overruling essentially what the records examiner provided as prima facie evidence? So, one moment.
Thank you, sir. And I will say that is not an accurate statement of the state of the law. An individual, the weight of authority on these cases at the appellate level is that an individual may sign their name in any manner that they choose. They can just sign an X and say that is my signature. It may not match what's on record with the Electoral Board, but that's not the legal standard. The legal standard is, did they sign their name? And how but the only way to know if that's a valid signature is to check the Electoral Board signatures. So it's best if it matches what's on the what's on file with the Electoral Board. But he signed his name 14 years ago, has obviously changed the way he signs it. Now it's just a DM. He's shortened it. The D and the M match the first and last name that is on the voter record, and that is what is sufficient to rehabilitate this signature. He can sign his name any way he wants. The issue is whether or not this individual this is a genuine signature of Derek McCurdy, the registered voter. This affidavit established it. He's not under any obligation to explain why he deviated from his 2010 signature when he registered to vote.
So I would recommend we do this is go one by one and make determinations each time instead of somehow doing it all at the end. And then the next question is how you look at these cases and what parties are arguing slight differences, but in reality, what we have here is we have 3 exemplars of a signature. We have something from the affidavit, which is a sworn statement. It is, by its definition, hearsay. This person is not here subject to cross-examination, but for purposes of efficiency, and pursuant to our rules, they're allowed as admissible evidence in these cases, so that we don't have every voter who signed the petition potentially having to be coming in under subpoena and testifying about them signing petitions. On its face, we have it as a signature exemplar at the very minimum, even not taking it for the truth of the matter that it asserts, not taking it as saying, oh, this definitely says this person voted. We have the ability to weigh that and say, well, does the signature actually, does it match? Anyone can go get, if they got a not genuine signature, the argument is then, well, they could go get another not genuine signature affidavit too, right? But that's the possibility. That's why we have to weigh all the evidence. You take that with the voter registration record and the petition sheets and put them together and try to find indicia of commonality throughout all of them. And you're the judge. This is all pure fact. Question of, does the person who signed the petition sheet, does that match the person's whose voter registration record, and is it the same person who signed the affidavit? And if you decide that that is true, then the objection should be overruled. And if that is not true, if the person's signature on the petition sheet is different from the voter registration and/or the affidavit, there's some difference, there's some problem between those, then the determination should be that the objection should be sustained and remain sustained as to the genuineness of the signature. That's kind of, you look for indicia of commonality, and that's, council noted one thing about that, there is no explanation about why the signature was different, so we don't have that in evidence in any form, but you still look through the three what we have is 3 exemplars of signatures, really 4. On the affidavit, the person gives 2, presuming that it's the same person, of course, and it looks like on this one especially it is, that the person gives 2 exemplars, the voter registration record, and then the petition. And we should find commonality between all 3 to say that the signature is a valid signature.
Well, I'm looking at 2 pieces of evidence. I'm looking at the petition and I'm looking at the affidavit. I don't have anything more than those 2.
You have the,
This is what I'm
oh,
looking
you have
at.
the on the screen is the certification,
Yeah.
and
Mhm.
you should have here are the affidavits that were just submitted to us.
What's in the email?
And there was,
The
you have them in
affidavit, what's in the
email.
emails? It's in
Then the
email.
copies here.
I don't know if the printed copy, but
For the affidavit? No, we have it in the email.
Oh, the email.
Yes.
Okay. Let me pull it up then. Huh? I'm sorry?
I'll see if I can get it.
Okay.
I believe the first one, it's about a 119-page document.
Is it up? No, it's blank.
Put it through.
You see it?
I see it.
Yeah,
yes.
okay, thanks. Thank you. I have a question for Ross. Attorney Fogarty, you mentioned about the Chicago Board case, or what the Chicago Board ruled, but that's not case law, right?
That's correct. That's not binding case law, but that case was appealed, and there is an appellate court order regarding that. There are some subsequent appellate court decisions regarding that process that I generally described as, and I think kind of takes a middle ground of what the parties are asserting, essentially.
Mhm.
How you review these is your factual determination. How can you determine, right now, this is presumptively an invalid signature and it was ruled that for example, that on the sheet 1, line 6, that the signature on the petition sheet does not match or is not the same person who signed the voter registration record. To rebut that, the candidate has proffered this affidavit that says that he really is the person who did it. It doesn't say that why the signature changed or is different, but that's just not in evidence. What we have is these exemplars, and it's up to you as the board to review
Right.
them and say whether you think they all kind of match, or they're all the same person, or if they don't. Right? I mean, that's what it boils down to, I think. Yeah.
Yeah,
This is the,
right. Yeah, I have
look it
that.
over here.
Yeah.
So, to this.
Yeah, I saw that.
So this is the original. Not sign that way. So I did sign in the future, GM only.
Well, the fact that the individual signed the affidavit, I think it's a big determination by me that it's the same person, and that's a valid signature.
So then we just need a motion to.
Motion to object, right?
Accept.
So,
that.
you would if you think it's the same person, then you'd move to overrule the
objection.
results and find that the signature is valid.
I would so move then.
Second.
Okay, motion made by Alderman Mike Seville, second, Claire Stellings. All in favor, say aye.
Aye.
Motion passed.
Thank you. The next objection is line 3, or I'm sorry, sheet 3, line 7. Objections were sustained to the signer not registered at address shown, the signer was not genuine, not signed by proper person, the signer's address is missing and incomplete. We offer the affidavit of Ari Pars, stating that they reside at 1357 Mononomoy Street, Apartment B, and that their signature appears on line 3, sheet 7. We also offer the candidates' nominating petitions and the certified voter record showing that at 1357 Mononomoy Street, Apartment B, the voter is registered to vote at that address. Her signature does match what appears on the candidate's petition sheet, and we ask for a favorable ruling and that the objection be overruled.
And on this one, the objection was sustained on not registered at address shown and an incomplete address. I'm certain that was likely because there's no apartment number listed on the petition sheet. And so we've been provided a voter registration certification for this individual. The signatures match closely enough, although that's not the basis for the objection. And so we would concede this one.
Was this one sustained, for just those, or was it for signature as well?
Oh, I'm sorry. You know what?
I was confused.
Oh, I was looking at the wrong line. My apologies. Okay, then we would say that the signature does not match,
Sorry, yeah.
for the record.
Sheet 3, this is sheet 3, line 7. So the voter registration record,
AP.
And I would submit that although it's not an exact match, this individual signed their name in the initials on their voter records, and is providing a sworn affidavit saying, yes, I did sign that. Sign at sheet 3, line 7. I am that registered voter. And the A in her name does match. It does bear a resemblance, and so does the P. The way that it kind of comes down early before the top. And so we would find that this is we would request that this is a valid signature on the objection. So there's 3 objections. that that the voter is not registered at the address shown, that the signature is not genuine, and that the address was missing or incomplete. So the individual here failed to write apartment B3. Now, the case law holds that the purpose of writing the name of the address is so the election authority can type that address in there and find the voter. You don't have it in there, then they have to search the whole city for this. Here, that's not at issue. The electoral board located the voter right away. 1357 Mononomoy Street, Ariu, Pars. So the voter is registered at the address shown. The fact that the signer's address is missing or incomplete, the cases hold that you can substantially comply with that. I cite Davis v. White, Davis and White v. Reed, 445 NE 2nd, 1337, where, and that's a Chicago Board of Elections case where, missing parts of the address were rehabilitated because they were able to, at the records or through the records exam process, they were able to locate the voter and overrule those objections. And then the first district has commented on this in Green versus Board of Election Commissioners, just saying that Section 10-4 seeks to preserve the integrity of the election process by ensuring that the signers are registered to vote at the address shown. Here, they established they are registered to vote at the address shown, so they've substantially complied with the requirements there. So each of these objections should be overruled by the board.
So if you're looking for a motion, I would vote to overrule then.
And find that this is a valid
It's a valid signature, yeah, looks the same to me.
Second.
Okay. Motion made by Alderman Mike Seville, second Clerk Stellings. All in favor say aye.
Aye.
Motion passed.
Next line?
Yeah.
Okay. The next line is sheet 3, line 8, the very next line of that on a candidate's petitions. That objection was sustained. Signer not registered at address shown, and signer's address missing and incomplete. Again, same issue. Apartment B was missing. The electoral board had no trouble locating this voter. Malika Pars at 1357 Mononomoy Street, apartment B, and the signer has substantially complied with 10-4, and we ask that this objection be overruled.
And so on this one, that's the one I was looking at. For the prior one, we would agree. The allegation is that it's an incomplete address, not registered at address shown, and we have a certification from Kane County. So we would concede that one. Concede that it has been rehabilitated.
Do we need a motion?
Yeah.
So moved.
Second.
Motion made Alderman Mike Seville, second Clerk Stellings. Say aye.
Aye.
Motion passed.
Next line, same page, sheet 3, line 9. Objection was sustained as to signer's address missing or incomplete. On sheet 9, the address of voter Laura Progo is written out clearly 1379 Eastwood Drive. The county of Kane is missing. However, the voter does have an affidavit where she states that she lives at 1379 Eastwood Drive in Aurora. There is no requirement that the county be stated in the election code, and even if there was, the election authority was quite easily found their address at 1379 Eastwood Drive, voter named Laura Progo. We ask that this objection be overruled.
Mr. Fogarty?
Yes, yeah, this one as well, we have no issue with.
So moved.
Second.
Motion made by Alderman Mike Seviol, second Clerk Stellings. All in favor, say aye.
Aye.
Motion pass.
Turning to sheet 4, line 5. The objection was sustained as to register, sign or not registered at address shown. I have the affidavit of Vincent Don, D-H-A-N, who states he resides at 1005 Apple Court. It is signed and notarized. On sheet 4, line 5, the name is Vincent Don, 1005 Apple Court. And we also have the voter record, which has a Vincent Don registered at 1005 Apple Court. We ask that this objection be overruled.
And we have no problem with that one also.
So moved.
Second.
Okay, motion made by Alderman Mike Seviol, second Clerk Stellings. All in favor, say aye.
Aye.
Motion pass.
Next objection is page 6, line 1. Objection was sustained as to the signature not genuine. As to voter Janet Sanchez, we offer the affidavit of Janet Sanchez attesting that she resides at 759 Spring Street and signed her name on sheet 6, line 1 of candidate Jasmine Garcia's petitions. Turning to sheet 6, line 1, the signature is a match from what the affidavit shows. And while the signature is not a direct match, admittedly, of the certification, it is a very close match in terms of the J to the affidavit, which was signed. Is not the J and the S in Janet Sanchez's cursive signature do have a tendency in commonality with the voter certification. The voter certification was originally registered in May of 2015, and 9 years later, she signed this affidavit a few days ago, and it does have some dissimilarities, but over 9 years that can happen. The main point is that the J and the S remain common and does match the signature that is on the candidate's petitions.
The objector contends that the signature on the voter registration record differs enough from the signature on the petition page and on the affidavit such that it's not a match. And we would contend again that to the extent that the affidavit is supplied as counter evidence to the finding of the records examiner, the affidavit does not explain why there might have been a difference. It is fine for counsel to speculate that over 9 years a signature changes. That may or may not be the case, but it's not in evidence. So we would ask that this signature objection be sustained.
Any questions from the board? Or motion?
I think the signatures are somewhat similar, and the fact that we have an affidavit stating to that effect, I would move that that we overrule the objection.
Second.
Motion made by Alderman Mike Seville, second Clark Stallings. All in favor say aye.
Aye.
Motion pass.
Thank you. Turning to sheet 7, line 6. Final report. The objection was overruled for signature not genuine. We have offered the affidavit of Peter G. Cozzoni. We also have we have 2 exemplars, as we've seen on the other affidavits. We have 2 exemplars on the affidavit of Mr. Cozzoni. He swears he did sign on the candidate's nominee papers at sheet 7, line 6. The signature on sheet 7, line 6 does bear an indicia of resemblance, especially given the context of how these petitions are typically collected. When you're on a clipboard, you might not have the exact same handwriting capabilities as you do when you're sitting at a table at an election authority. Nevertheless, the exemplar, which does have some commonalities, the exemplar with the certified voter record does have some commonalities in that the P and the C of his first and last names are similar, and that was signed over 25 years ago. We ask that this signature be overruled as well, this objection be overruled as well.
And again, we oppose. And to the extent that you're considering the assertion that maybe this was signed on a clipboard while the person was standing up or something of that sort, or that this signature has changed over time, those are facts that are not in the record. They are not in the record because the affidavit that has been offered does not specify why the signature does not match. We argue that it does not match. There might be some similarities, but not a sufficient match to overrule the judgment of the records examiner. But again, the failure of all of these affidavits to state why there is a difference. There needs to be more than just an affidavit. There needs to be evidence as to why the difference. This affidavit does not provide that.
And I believe that's an incorrect statement of the law, and the affidavit speaks for itself that that this signer, who's registered to vote, did sign the sheet where indicated.
I would move to overrule them.
Second.
Motion made by Alderman Mike Seville, second Clark Stallings. All in favor say aye.
Aye.
Motion pass.
Next is sheet 7, line 8. The voter is John Koranek. We offer the affidavit of John Koranek. that he did in fact sign sheet 7, line 8 of the candidate's nominating petitions. And there is a match between his signature and his handwritten name as well on between the affidavit, the candidate's petition sheet on sheet 7, line 8, and the objector's signature, the voter's signature on the certified record of the Kane County Clerk, which is dated 1992, 32 years ago. And I would also point out the commonalities between the J and the K on his signature from November of 24 and the year of 1992.
And our contention is that it is not a sufficient match to allow you to overrule the ruling of the records examiner.
Yeah.
I would move to overrule.
Second.
Okay. Motion made by Alderman Mike Seville, second Clark Stellings. All in favor say aye.
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 Motion passed.
Next, on the, we turn to sheet 9, line 7. The objection was sustained as to signer's signature is not genuine, not signed by proper person. We offer the affidavit of Naira M. Acevedo, using similar arguments that we've incorporated thus far. The signature on the affidavit bears resemblance to the signature on sheet 9, line 7. I'm sorry. The in this case, the signer on the affidavit seemed to scribble in their initials on that, and they have signed the affidavit. It does match the voter's certification, and she is attesting under oath that she did in fact sign sheet line 7, and she is the registered voter, Naira M. Acevedo.
Kevin, was this some of the additional matter that you sent later on Friday night?
No. It might have been, that might be out of order, though.
Okay, what's this person's name?
Naira Acevedo. So look here, see if it's right here. Go to page 1.
I think it's like page 73 of the PDF.
Yeah, so she's like at the end. All right.
So we would oppose rehabilitating this signature. I don't know what exactly is on the petition, and maybe that is someone's initials, but it certainly does not match the voter's record, does not match the signature of the affiant on the affidavit. And again, there's no explanation as to why that is different. Is it the person's initials? We don't know. So we think this one should stay sustained.
Is the name spelled correctly? The printed name even?
The printed name is spelled correctly, and it does match.
The first name? I mean, it looks different to me from,
N-E-Y-R-A, Acevedo.
I don't see an E, but
Yeah,
I might
that's
not
fair.
be looking.
It is, the Acevedo does bear a resemblance. The printed name does bear a resemblance. And again, the weight of the case law says it doesn't, your signature is whatever you attest to. It could be X. It could be just up and down scribble that doesn't really resemble your name, and it need not be consistent. Just be that you are the individual signing. This affidavit establishes under oath that she was the one who ascribed her name to that. And the fact that it is the first letter of her name with an A is perfectly legal under the law. And this has been sufficiently rehabilitated. We've met our burden.
So the objection is that this signature does not, it's not genuine. It does not match what is on file at the Kane County Clerk's office. That has been sustained. What's now before you is an affidavit that does not tie the signature on the petition page to what is on file at Kane County. Anybody can come in with an affidavit and say, oh yeah, that's my signature, but why does it not match? That is the issue. And the affidavit doesn't say, and the signature on the sheet is not close to what's on file at Kane County.
And that's simply not, again, that's not an accurate statement of the law. What's at issue is, did the individual who's actually registered to vote, did they subscribe their name to these nominating petitions? And this person is swearing, yes, I subscribed my name. It might not be a direct match of what the Kane County Clerk has on file, but it need not be. All it need be is that it be her signature. And the fact that it doesn't match is irrelevant. It's not helpful to meeting my burden, but I still have met my burden by the affidavit, by the individual swearing, yes, I signed my name there.
The question is, how do we know it is the same person? You know it's the same person by a reasonable match with the records on file at Kane County. And what you have before you is not sufficient to let you know that that is indeed the same person. That is the issue.
Yeah, didn't look like the same. And especially when you use, normally we use in middle name or middle initial. If you sign, normally we put it the middle initial. So in this point, and the certificate is with the middle initial M, and she didn't use it in the affidavit, and she not use it in the petitions.
And again, the law does
See?
not require her to have a consistency of a signature. The law requires that it just be her signature. And if she was called to testify today, she would testify, as this affidavit says, that she did, in fact, scribe her name and print her name and address on that line. And that's the evidence before you.
And the key is, if she were called today, an affidavit is by its nature hearsay. If this person was produced here today and said, yes, this is what happened, etc., then you would have enough to overrule this objection. But right now, you do not have enough to overrule this objection.
And my question before looks like the first name is spelled incorrectly when printed. So I would say that we sustain the objection. Motion to sustain the objection.
I'm second. Okay, motion by Claire Stellings, and I'm second. Alderman Juan Garza. All in favor, say aye. Aye.
No. I
Just
think
one
the
no?
affidavit is enough. It shows that this
yes, one no?
person signed it.
Two to one, so
Yes.
the objection will remain sustained.
Mhm.
Thank you. Mr. Fogarty, I now turn to sheet 13, line 2. And that should be found at the, towards the end of your.
Okay, thank you.
The affidavit of Eduardo Torres.
Are you doing 9-9 or?
13, line 2.
Oh.
Is that out of order? What's 9-9?
I don't, you have an affidavit in here for sheet 9, line 9.
This is not sustained.
Fair.
Skip that one. Yes, Mr. Seckler, pass that one and move to sheet 13, line 2, the affidavit of Eduardo Torres. The objection was sustained as to signer's address missing or incomplete. Mr. Torres provided his residence address at 1313 Menominee Street. The affidavit states that he resides at 1313 Menominee Street, Apartment A. And the election authority found Eduardo Torres's signature, which does match the signature on the affidavit. And he is registered to vote at 1313 Menominee Street, Apartment A.
And we will concede that one.
I would approve that then. I would make a motion to approve that then.
Okay. Motion by Alderman Mike Seville,
Second.
second, Jennifer Stellings. All in favor, say aye.
Aye.
Motion pass.
Turning to sheet 15, line 7, candidates petitions. The objection was sustained as to signature not genuine, as to voter Jacqueline K. Gordon. Ms. Gordon has filled out an affidavit, notarized, swearing and attesting that she is a voter at 651 Westgate Drive, and that she signed her name at sheet 15, line 7. The signature, which does have some overlap from the line below it, but you can definitely see the G in her last name bears a resemblance to on the candidate's petition sheet, and then also the G and the swirly nature of the signature bears a indicia of commonality, and we ask that this objection be overruled.
Our contention is that there is not a sufficient match. It's not clear, given the signature of the voter on the certification and the petition sheet, that this is the same person. That's our contention.
Motion to overrule. Objection?
Yeah, I think the signatures look pretty similar in its own fashion, so I would second that.
Motion made by Jennifer Stallings. Second, Mike Seville. Vote no?
Mhm.
Vote no? Okay.
I know I'm voting yes.
Oh, you voted yes?
I'm voting yes that this is to be overruled. Is that
Okay.
correct? That's the motion, is that correct?
Yes.
Yes.
Okay. So motion passed.
Turning to sheet 20, line 7, the records examination. The objection was sustained as to signature not genuine. We tender the affidavit of Jill Keller, who attests that she did sign on sheet 20, line 7, and she is registered to vote at that address. We have 2 exemplars of her signature on the affidavit that bear resemblance to the signature on sheet 7, on sheet 20, line 7, and there is a match to her name with the voter certification.
We will maintain our objection on this case. We would concede the J looks similar to what is contained in the certification and the affidavit, but the last name does not look similar enough for a finder of fact to conclude that this is a genuine signature.
Just noting for the record that voter record of Kane County was, that signature clip is from 2000 when she, the most recent date that she was registered. So 24 years ago.
I move to overrule.
Second.
Motion made by Alderman Mike Seville, second Clerk Stallings. All in favor say aye.
Aye.
Motion passed.
Next, turning to sheet 21, line 2 of the objector's petition. The objection was sustained as to signature not genuine. The voter printed their name, again, not, that is completely acceptable under the election code. However, when the record examiner went to go match her signature, they had a cursive signature. So she obviously sometimes prints her name and sometimes signs her name. But in any event, she signed an affidavit that she did in fact sign the candidate's petition sheets on sheet 21, line 2, and her signature on the affidavit is a direct match to the voter signature, certified voter records with Kane County.
And we don't believe that the signature on the petition matches what is on file at Kane County. I can see that it is a printed version of a signature. But again, the affidavit is insufficient because it does not state, for instance, my signature differs because I printed instead of signed in cursive. And without that key piece of evidence in the record, I don't think that you can conclude that, oh, this is just this person's printed name.
And
So for that reason, yeah, we believe that this should remain a sustained objection.
inherent in that argument is that this would include false swearing. She doesn't need to state why there was a difference. It's obvious that there was a difference. She's swearing that she signed her name on that page and that she's a registered voter.
And no, we're not alleging any type of false swearing. We're alleging a lack of evidence.
I would move to overrule.
Second.
Okay. Motion made, Alderman Mike Seville, second, Clerk Stellings. All in favor, say aye.
Aye.
Motion
Aye.
pass.
Turning to sheet 23, line 3. We have the affidavit of Arabia Patino. The objection was sustained as to voter's signature not genuine. Here we have the printed name where the person is attesting that their cursive signature is printed. And you know, for whatever reason. And they printed their name twice on the petition sheet and on the voter record. It does appear to have printed indicia of commonality between the two of Arabia Patino, the voter at 203 Maplewood Drive.
I think there's enough commonality as well. I would move to overrule.
And if could I speak to it first, just for the record, please? Yeah. For the reasons stated with regard to the prior signature, we believe this should remain sustained. It is printed. There's not an explanation of why there is the difference, and that's our position. Thank you.
Second.
Okay. Motion made by Alderman Mike Seville, second, Clerk Stellings. All in favor, say aye.
Aye.
Motion
Aye.
pass.
Turning to sheet 23, line 6. The objection was sustained as to signature not genuine. We have the affidavit of Kenya Patino, who states under oath that they did in fact sign at sheet 23, line 6, and that they are a registered voter at 921 Colorado Avenue. The voter certification from Kane County also finds Kenya and Patino registered to vote at 21 Colorado Avenue. And we ask that this be overruled.
So we do not believe that there is sufficient match between signatures on the petition and the affidavit with what is on file with the County of Kane. So this should remain sustained.
Motion.
Move to overrule.
Motion made by Alderman Mike Seville,
Second.
second, Clerk Stellings. All in favor, say aye.
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 Motion carries.
Next, turning to 23, line 10. The objection was sustained as to signature not genuine. We offer the affidavit of Antonia Gregory, who states that they reside at 951 Oliver Avenue. Their name appears on sheet 23, line 10, and that they personally placed their name on that petition sheet. The signature on the affidavit and the nominating paper is a match, and she is registered to vote as Antonio Brianna Gregory. She signed her name Brianna Gregory with the certification. She obviously uses both names, and the Gregory on her voter signature, on her voter certification, does bear a resemblance in both the G and the Y. The G at the beginning and the Y at the end of her signature. We ask that this be overruled.
Yeah, and our contention is the signature as set forth on the petition does not match. It's obviously a different name that is used as a registration signature, so it does not match.
Move to sustain the objection.
Motion made by Clerk Stellings, second. Second myself.
No, I'm not second.
Oh, you're not second?
No, I'm not second.
Okay. So there's two yes, one nay.
Yeah, you should vote. still.
Yes. Mhm. So, he will no.
Right.
Yeah, so I will yes.
I vote no.
Okay.
Turning to sheet 29, line 9.
Did you say sheet 20?
Sheet 29, line 9 of the record examination. The objection was sustained as to not genuine. The voter found in the record was Michael S. Wasaki. We have the affidavit of Michael S. Wasaki stating that he resides at 1520 South Lawn Place. His name appears on sheet 29, line 9, and he did in fact place his name on that petition sheet. It is a very wispy and swayly signature, and has a similar resemblance to what's on both the petition sheet and what's on the voter certification.
Excuse me one moment while I find that.
Oh yeah, apologies.
It's all right. Yeah, our contention is that it's not a sufficient, thank you, it's not a sufficient match to what is contained on the voter registration record.
I move to overrule.
Second.
Motion by Alderman Mike Seville, second Clerk Stellings. All in favor, say aye.
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 Next is sheet 34, line 3. The objection was sustained as to voter's signature not genuine. I offer the affidavit of Andrew Kuzrian, who swears under oath he resides at 414 North Fordham Avenue. He swears to his cursive signature. And there is a match between that cursive signature and what appears on the sheet 34, line 3, and the voter record.
We don't believe that there's enough commonality in these signatures, and I believe the voter's name, and it's interesting, is Kuzreau, K-U-S-R-E-A-U, rather than Kuzrian, but you wouldn't know because it's difficult to read. And there is not enough similarity between what is on the record and what is on this petition.
And I apologize for this pronunciation. It is Kuzreau, as the clerk for Kane County correctly found Andrew Kuzreau's voter registration record. And, you know, it's an incomplete clip from the certification, but you can tell the A and the size of the font are very similar.
In addition, I just noticed actually the affiant did not sign this affidavit. The notary instead signed the affidavit. So it should be disregarded for that reason as well.
However, under the de facto notary rule, if the affiant signs the affidavit, believes they're under oath, and the notary makes a mistake in the jurat somewhere, it should not be held against the affiant as how the law is written. So this individual believed they were under oath. They did sign their name on this affidavit, and there's no evidence that they don't believe they're under oath, and the error of the notary should not be held against the affiant.
So typically, the de facto notary doctrine would protect someone if they were sitting in front of a notary whose commission had expired, or if the notary did not stamp the affidavit, or if the notary was from out of state or something like that. It does not protect someone who does not actually sign what they're swearing to. It doesn't. That's not what the de facto notary doctrine does.
Do you have an opinion on this, Ross?
On this one, we see that someone in blue ink filled out most of the affidavit, and they actually filled in this person's name in the jurat. So we don't know who that person is because there's a signature. My cursive signature as an exemplar is in black ink, and then it seems like the notary signed in black ink and filled out the rest of the jurat. We don't have any evidence here that the affiant signed this affidavit under oath at any point. So I don't know if this particular affidavit would be admissible under our rules. So.
Motion to sustain the objection.
If I may be heard, even if you don't use the affidavit, you still are permitted to use King County voter records and yourself review the decision of the records examiner, and there is certainly indicia of commonality between these two signatures. You also have another exemplar where the individual signed their cursive signature, which they believed was under oath. So even if you discount the affidavit, it's still more probably true than not, which is our burden, that this individual Andrew Cusero did sign on sheet 34, line 3.
Mr. Fogarty, anything further?
No, our position is clear.
I renew my motion to sustain the objection.
What?
I'm not going to second.
Okay, so I'm second. So, motion pass.
You should
Mike?
do a vote.
Mike, you need to vote.
My vote is no.
Okay, so it's 2 yes, 1 no.
Thank you. Turning to sheet 36, line 8. The objection was sustained as to signature not genuine. We offer the affidavit of Eugene P. Baxendale, who is attesting that he is the registered voter. It resides and is registered to vote at 915 West New York Street in Aurora. That he signed on sheet 36, line 8. We have 2 exemplars of his signature that bear resemblance to the signature on the candidate's petition and a striking resemblance to the voter certification at the Kane County Clerk's office, which has been on the file for nearly 50 years.
One moment, please.
Yep, I'm sorry.
That's all right, bud. Eugene, yeah.
Baxendale?
This was in the disclosures, right? I just couldn't find it. This-
It was. It was
Okay.
out of order.
It's in the Rule 8, yeah.
6-8.
Counsel, if you say it was in there, you don't have to go search. I got it.
Well, we would contend that the signature on the petition is not a sufficient match to the Kane County certification for this voter.
Motion to overrule.
Second.
Motion made by Jennifer Stellings and second Mike Seville. All in favor, say aye.
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 Turning to sheet 38, line 8, in the final report. Mr. Fogarty, I believe this is a this is a DuPage objection.
I don't see it in DuPage. Is it? Am I missing it? Okay, thank you.
The objection was sustained as to signer not registered at address shown. It was an individual named by the name of John Tan. in the records report, in the final examination report, they did locate, or they have the name down as Joan. Joan illegible. My apologies. So we have the affidavit of John Tan stating that his address is at 3425 Charlemagne Drive in Aurora, Illinois. We also have the certified record of the voter finding him at the address of 3425 Charlemagne Drive.
We will certainly concede that there is a voter, John C. Tran, at 3425 Charlemagne Drive. According to the records in DuPage County, our position is that the signature on the petition sheet is not sufficient to connect that voter to that signature.
That is not the objection. The objection is that the voter is not registered at the address shown. This affidavit, signed by John Tan, establishes that he does reside at 3425 Charlemagne Drive, and the voter certification from the DuPage County Clerk's Office shows that they did find a John C. Tan at 3425 Charlemagne Drive in Aurora, Illinois. So again, this record examination was conducted outside of our presence. We don't know why they decided to say Joan illegible when they did have a John Tan record, and you can, it's not as clear as you would like, but it does show the name, you know, a J ending with an N, and then a three-letter word. So you can infer that that is John Tan, and he's swearing under oath that he did sign there. So he is registered to vote at that address shown, and the record exam got that wrong, and we ask that that be overruled.
So we think the record shows that somebody may be registered there, but that it's not necessarily this voter. That's what the objection was, that the person was, this voter, not registered there. And so that's right. So we don't think that there is enough similarity to demonstrate that this person is registered at the address shown. That was the basis of the objection.
Motion to sustain the objection.
Okay.
Sustain, yes.
What?
I'm gonna move to overrule.
Okay, I'm second.
Second, which one?
Which one?
And the first one,
Move to sustain.
staying,
Okay,
yeah.
so keep it out.
Mhm.
Okay.
Okay,
Vote?
vote,
Vote.
yes,
Yes.
No.
okay, yes.
Okay, turning to sheet 43, line 2. Another Will County.
40.
The objection was sustained as to signer's signature is not genuine. We offer the affidavit of Michael A. Dwyer, who testifies that under oath that he signed the signature on sheet 43, line 2, and that he is registered to vote at 1178 Clover Drive. And then we also have the voter certification from the DuPage County Clerk with a match with the signatures.
And our contention is that the signature on the petition sheet does not sufficiently match the certification from the election authority. This individual, Michael A. Dwyer, as signed with the county of DuPage, the D in Dwyer looks quite different to me, and the rest of the signature does not bear a sufficient resemblance.
And if you look at his signature from, November 16th, 2024, compare it to his signature in the year 2000, they're pretty dead on of a match with the voter certification.
I think they look similar, especially the D. I would move to overrule.
Second.
Okay, motion made by Mike Seville, second, Jennifer Stellings, all in favor say aye.
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 Turning to page, sheet 44, line 4. Signer's address is missing or incomplete. We have the affidavit of Rich Messenger, who under oath states that he resides at 75 South Anderson Street, apartment 1, that he did sign the candidate's nominating petition on sheet 44, line 4. And he provides his signature, which is a match to not only sheet 44, line 4, but also the voter certification, which the Kane County Clerk was able to find, and that he does reside at apartment 1 on 75 South Anderson Street, and that the signer has substantially complied with the requirements of 10-4.
We're fine with this one.
That's-
Turning to sheet 44, line 8.
We need a
Hold on one
motion.
second, we should have a.
We need a
We need
motion
to make the
then.
motion.
Oh, I'm sorry.
I would approve then.
Second.
Okay. Motion made by Alderman Mike Seville, second Clerk Stallings. All in favor, say aye.
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 Motion pass.
Turning to sheet 44, line 8. Council, this is an out of order one, so.
It is?
Is it? Look
Is it?
towards the back. Is it not?
Wow.
Do you have it?
I'll go in order and I'll tell you. One moment. You say 44, line 8? All right.
Yes.
It is out of order, but I'll find it.
Let me know when you're ready.
You can go ahead, Kev.
Okay. The objection was sustained as signer's address missing or incomplete. The voter wrote, we have the affidavit of Victor Heights, who states under oath that he resides at 512 East Downers Place, Unit A. He did sign sheet 44, line 8 of the candidate's nominating petitions, provides exemplars of his signature that match the nominating papers and the voter certification. And the Kane County Clerk was able to locate this voter at 512 East Downers Place, Unit A. We ask that this objection be overruled.
And given what has been presented and what was sustained, we concede this one.
So moved.
Second.
Motion made by Mark Seville, second Jennifer Stallings. All in favor, say aye.
Aye.
Turning to sheet 45, line 5. The objection was sustained at the record examination with regards to signature not genuine. We have the affidavit of Lawrence Rosenthal, who attests that he resides at 70 North Root Street, and that he did in fact sign sheet 45, line 5. And we have exemplars of his signature on the affidavit and the voter certification that do provide a match.
The objector would contend that there is not a sufficient match in these signatures.
Motion overruled.
Second.
Motion made by Alderman Jennifer Stallings, second Alderman Mike Seville. All in favor, say aye.
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 Turning to sheet 47, line 9. The objection was sustained as to signature not genuine. We have the affidavit of Jesse Salty Giral, who states that he resides at 335 LR8 Drive, and that he did in fact sign sheet 47, line 9, provides 2 exemplars of his signature that do match line 9 and do match his certification with the Kane County Clerk's office.
The objector contends there's not a sufficient match.
Counsel, I can't find the original in here.
You can't find it? We can pass this one.
Okay.
If I locate it at some point, we
Yeah.
can come back to it. Okay, turning to sheet 51, line 1. The objection was sustained as the signer is not registered at address shown. We have the affidavit of Corey Klausing Casper stating that she resides at 18 South Root Street, and that she did in fact sign her name at 51, line 1. She provides exemplars of her signature, and the Corey does, the K does match the signature clip of the individual who was swearing under oath that she signed the papers, and it does match the signer's signature on the petition sheets.
Oh, okay. Well, the voter is registered as Corey Klausing, and the signature is of Corey Casper. Presumably, there was a name change, but that would be presumably. We don't know. So we don't think that the signature can match, or that the registration is accurate.
Motion to sustain.
Second.
Okay, motion made by Jennifer Stelling, second Alderman Mike Seville. All in favor, say aye.
Aye.
Turning to 53, line 2. We have the affidavit of J. San Sanders. The objection was sustained as to signer not registered at address shown. The petition sheet on sheet 53, line 2, is a little bit 1083, and it is a little bit difficult to read on that, but the King County Clerk had no difficulty finding that a letter J, then son, S-O-N, in 2 different words, Sanders, does reside at that address of 1083 Cascade Drive that he attests to in this affidavit, and his signature does bear a resemblance on the affidavit, nominating petitions, and voter certification.
Well, the address on the petition is, well, it looks like something on Ivy Lane and not Cascade Drive. And so we would stand on this objection.
Motion to sustain.
Second.
Okay, motion made by Jennifer Stelling, second Mike Seville. All in favor, say aye.
Aye.
Turning to sheet 56, line 3. So the objection was sustained on the basis that the signer is not registered at the address shown. We offer the affidavit of Gerald Nicholas, stating under oath he does reside at 2150 Baker Street, that he did sign the candidates nominated petitions on sheet 56, line 4, and that is sworn under oath. On the petition sheet, he writes 2150 Baker Street, and the voter certification shows that Gerald Nicholas does in fact reside at 2150 Baker Street. Thus, we ask that this objection be overruled.
So this signature was objected to on the grounds that the signer was not registered at the address shown and that the signature was not genuine. 56-4, right? Yeah.
I'm sorry, 56-4, yes.
Okay. Yeah,
I
that's,
had the wrong sheet. I had the wrong sheet. My apologies.
that's okay.
May I
Oh, no,
start over
yeah,
again?
of course.
My apologies. I had the wrong sheet. Sheet 56, line 4, the objection was sustained as to signature not genuine. We offer the affidavit of Gerald Nicholas, who attests that he does reside at 2150 Baker Street. He did sign sheet 56, line 4. There are 2 exemplars of his signature, which do bear resemblance to the candidates' nominated petitions. He also, his voter registration card, which was originally signed nearly 24 years ago, bears resemblance on his last name, Nicholas, and we ask that this be counted as a good signature and that the objection be overruled.
Our contention is that the signatures on the affidavit and the petition are not sufficiently similar to what is on file with Kane County, so that you do not have sufficient evidence to make the finding that this was indeed the same person. So because the signatures do not match, and the G's are different, the G's are different, and the last name on the petition, it almost looks like there's a middle initial V before it. It just does not match enough for me to say yes, that's okay, and I don't think you have enough in front of you either.
Motion to sustain.
You will know?
I'm going to vote no, yeah.
Okay, yes. So 2 yes, 1 no?
To sustain the.
Mm-hmm.
Turning to sheet 62, line 3. This objection was sustained as to signature not genuine. We have the affidavit of Jose L. Gonzalez attesting that he resides at 1730 Heather Drive, that his name appears on the candidate's nominated petitions, and that he did personally place his name on that petition sheet at sheet 62, line 3. We have some exemplars of his signature where he has signed the affidavit in a very similar manner to the candidate's nominated petitions, and the exemplar from the voter registration record, which was originally registered nearly 23 years ago, shows he did sign his full name and not his initials, but the initials that are present are similar to the initials that he is now signing on the affidavit and the candidate's nominating petitions. We ask that this objection be overruled.
And our contention would be that the signatures on the affidavit and the petition are similar, but they're not sufficiently similar to what is on file with Kane County. And there's no information that would allow you to conclude a reason why they are not similar. And so, because they do not match, we would ask that this signature objection be sustained.
Motion to sustain.
Second? So, you will know?
Vote no.
Okay. 2 yes, 1 no.
Turning to 63, line 1. I believe this is a Will County. Objection as well. The objection was sustained as to signer's signature is suspect. Their words.
It's DuPage County, and I don't know what's going on over there. It's suspect.
Yeah.
That was not the objection, but that's what's on the form here.
In any event, a review of the affidavit in sheet 63, line 1, it shows a dead match in between the cursive signature and the way that her N begins, the very unique squiggly lines on the N, which is also present on the voter's signature, and her on the voter certification signature clip. And her last name is very similar, especially the way that she ends it with that swirl and wisp down. It's present on the affidavit and the voter certification.
Yeah, on this one, we would agree. The certification matches the affidavit, and on this one, we believe it was properly rehabilitated.
So moved.
Second?
Motion made by Maxwell, second Jennifer Stelling. All in favor, say aye.
Aye.
Motion pass.
Okay, turning to sheet 71, line 1. The objection was sustained, that the signature is not genuine, not signed by the proper person. We have the affidavit of Martin Angel Alanis, who swears under oath that he resides at 1651 Roanoke in Aurora, Illinois, and is registered to vote at that address, that his name does appear on sheet 71, line 1. He gives exemplars of his cursive signature, which are an exact match to what was signed on the petition sheet. He also printed his name in the affidavit, which bears a striking resemblance to the printing that is on the voter certification that is on file with the Kane County Clerk's Office. And I believe Mr. Alanis is present if the board would like to inquire as to the genuineness of his signature.
Given the match between his printed name and what is on file at Kane County, I don't think Mr. Alanis's testimony is going to be necessary. Yes, I would concede that.
So
one.
moved.
Yeah.
Second.
Okay. Motion made by Maxwell, second Clerk Stelling. All in favor, say aye.
Aye.
Motion pass.
Turning to sheet 72, line 4. The objection was sustained as to signature not genuine, not signed by proper person. We offer the affidavit of Linda Wade, who states under oath that she resides at 1159 Kingsley in Aurora, Illinois, that she did, that her name appears on sheet 72, line 4, and that she did place her name on there herself. She provides 2 exemplars that are matches of what appears on the candidate's nominating petitions and that with what's on record with the board.
The objector maintains the objection to this signature on the grounds that the signature on the petition sheet is not sufficiently a match to what is the registered name. I would also note that it almost appears as if there's an extra letter in the last name of this signature. I would wonder whether lines 3 and 4 were perhaps signed by the same person, as is sometimes the case with what could possibly be husband and wife.
Questions or motions from the board?
Move to overrule.
Second?
Motion by Alderman Mike Seville, second Jennifer Stellings. All in favor, say aye.
Aye.
And turning to sheet 73, line 8. The objection was sustained as to signature not genuine. We have the affidavit of Laura Chmielewski, stating that she resides at 1856 Chase Lane, that she did sign sheet 73, line 8 of the candidate's nominating papers. She provides 2 exemplars that appear to match the shortening of her name that appears on the petition, and the L and the C from her affidavit do bear a resemblance to the certification with the King County Clerk's Office, and the weight of evidence demonstrates that this was in fact the signer of the candidate's nomination petitions.
The objector would contend that there's not a sufficient match between the Kane County record and that which is on the petition, and further that the signatures on the affidavit match what's on the petition rather than what is on file with Kane County.
Motion to sustain.
On second. So you vote no? You vote?
Yeah, I vote no.
Okay. 2 yes, 1 no.
Okay, and finally turning to sheet 27, line 3. The objection was sustained on the basis that the signature is not genuine, not signed by the proper person. The signature of Ariana Dahlman appears on sheet 27, line 3. The voter record of Adriana Dahlman is a direct match to the signature that appears on sheet 93. And we've also offered true and accurate copies of the statement of candidacy of candidate Ariana Dahlman of Aurora, Illinois, for Alderman at Large, residing at 1030 Celebration Drive, with her sworn statement of candidacy. That sworn statement does have a direct match to sheet 27, line 3. We also offer a true and accurate copy of her loyalty oath. Again, both of these documents are in the board's possession, and I present true and accurate copies of her signature and offer them for the purpose of a direct match between the candidate signatures that appear on the loyalty oath and the statement of candidacy, and when she signed in her capacity as a voter on page 20, sheet 27, line 3, in support of the candidate's nominating papers. Combine that with the voter records on file with Kane County, the striking similarities of all of them, and this objection should be overruled.
Okay, so there is not an affidavit from this voter. We will, I am not suggesting that these are not the true and correct copies of a statement of candidacy and loyalty oath, but because there is no sworn statement from the signer saying that this is indeed my signature, we would ask that this objection continue to be sustained.
Motion to overrule.
I'll second that.
Motion made by Mike Jennifer Stelling, second Mike Seville. All in favor, say aye.
Aye.
Anything else? Sure. Can you find it? Oh wait, that's what you did not have that? You do not have the original on that? Okay, well, I don't believe we can produce it then, and we will rest on our Rule 8 motion.
By my count, as a result, the candidate has overturned 25 signatures. Is that everyone
Yes.
knows?
I have 24. Do you want to?
Hold on, let me.
But I don't think I have a ruling on Mr. Saltongerald.
I didn't.
I don't have the original, so
I didn't pass. I didn't
okay.
count
so
that one.
we have not.
Okay.
I just had I just can't produce the original.
Okay.
So I'll try to quickly summarize to make sure we're all on the same. Sheet 1, line 6, the overruled. Sheet 3, line 7, it's overruled. Sheet 3, line 8 is overruled. Sheet 3, line 9 is overruled. Sheet 4, line 5 is overruled. Sheet 6, line 1 is overruled. Sheet 7, line 6 is overruled. Sheet 7, line 8 is overruled. Sheet 9, line 7 was sustained by 2-1. Sheet 13, line 2 is overruled. Sheet 15, line 7 is overruled. Sheet 20, line 7 is overruled. Sheet 21, line 2 is overruled. Sheet 23, line 3 is overruled. Sheet 23, line 6 is overruled. Sheet 23, line 10 was sustained, 2-1. Sheet 29, line 9 was overruled. Sheet 34, line 3 was sustained, 2-1. Sheet 36, line 8, oh, I had marked that. Sheet 36, line 8 was overruled. Sheet 38-8 was sustained, 2-1. Sheet 43, line 2 was overruled. Sheet 44, line 4 is overruled. Sheet 44, line 8 is overruled. Sheet 45, line 5 is overruled. 47, line 9 was passed. 51, line 1 was sustained. 53, line 1 was sustained. 56, line 4 was sustained, 2-1. 62, line 3 was sustained, 2-1. 63, line 1 was overruled. 71, line 1 was overruled. 72, line 4 was overruled. 73, line 8 was sustained, 2-1. 27, line 3 was overruled. So that it's, I saw what I did. It's 24. Is that,
That's what I have as well.
Okay. That's my number 2.
in the board's numbers, that's,
I had in 24 as well.
okay, based on,
What are we doing with 47-9? I know you said
it's
pass.
just
when you went through.
passed, so that
Okay,
it remains sustained, I guess,
Okay.
at this point. So that means the candidate has revived enough, I guess then it moves to the objector if they have anything to present, but nothing was disclosed. so-
No, that's right.
Okay. So based on that, it would be appropriate then for the board to move to I guess, to adopt and incorporate we made those findings, so the board would then move based on the findings of the Rule 8 hearing and the evidentiary hearing that the candidate has 24 signatures, or not 20, it has revitalized 24 signatures, and then therefore does have a sufficient number of valid signatures to obtain ballot access for the office of mayor for the city of Aurora.
So moved.
second.
Okay, motion made by Alderman Mike Seville, second Clerk Stallings. All in favor say aye.
Aye.
Okay, motion passed.
And then, so it'd be appropriate then for a motion to overrule the objector's petition and find that the candidate should be placed on the February or April ballot.
So moved.
Okay, motion made by Alderman Mike Seville,
Second.
second Jennifer Stallings. All in favor say aye.
Aye.
Okay,
And like we've done, the Illinois Election Code requires that these decisions be made in writing and that the board approve those written decisions in open session. What we'll do is prepare a written decision that reflects everything the board did today. And we'll just have to pick a date to come back and serve and sign those decisions in open session. We have one other decision we have to do as well. And we finished one. I would suggest then, we're coming back on the 3rd at 4:30 PM. This will be, there's nothing else to do other than to execute the final written decision. I would suggest, if it works, that we come back on December 3rd at 4:30 PM, just to have it all done together.
okay. Perfect.
You need a motion to that
Yeah.
effect? So
I
moved.
Move to recess this matter and continue this hearing as well as the hearing in case 02 to December 3rd, 2024 at 4:30 PM for the purpose of reviewing, executing, and serving the final written decision in this matter.
Second.
Okay, motion made by Alderman Mike Seville, second Clerk Stallings. All in favor say aye.
Aye.
Okay. Thank you.
Thank you very much.
Thank you.
Thank you, members of the board.
Thank you, counsel.
Motion to adjourn or anything?
Motion to adjourn?
We need a
Oh,
motion to adjourn?
We just did, so,
Okay, we're fine.
yeah.
Okay.
All right.
We can do, oh, why don't we do that? Are there any other matters or public comments that come before the board? That being said, we need a motion to recess this matter until 4:30, December 30th, 4:30. Oh,
So moved.
we have a
Oh,
one public
I'm
comment.
sorry, I'll take it.
I just wanted to express my feelings in regards to what happened today. Obviously, this is not what I was looking for, but it's obvious that everything that was said from the beginning about me running for mayor was not exactly what happened. I did submitted my documentation on October 16, and the intentions were there to submit it with all my paperwork. It was said as well too that, you know, we were trying to force a primary, which was not true because it was shown that I also mentioned that I was starting to run back in May. So to me, this is something that obviously this is not what the community was looking. And one of the things that I've always suggested was that it was given an opportunity for everybody who was deciding to run for office. Thank you.
Thank you, members of the board. Just briefly, John Lash, 710 South 4th Street, Aurora, Illinois. I want to thank you for convening, deliberating, and really taking your time to look through every signature. I've seen these hearings go forward before where one side throws off a bunch of affidavits and are simply subtracted from the numbers. You definitely did your work here to deliberate and make some very challenging decisions. To Karina Garcia, I want to thank you for representing your community, and just to say as another member of the community and as someone who believes that your voice is one that the community would like to vote for, we will be supporting you if you choose to take the next step to appeal these findings. And I want to add that Karina Garcia was the first person to announce her candidacy in this race, so for the objector to even file this motion and suggest that she is a sham candidate is downright offensive. And to the objector, finally, this is a desperate attempt to narrow the field of candidates to achieve a political goal and to suppress democracy to advance a political goal and a political agenda for an unpopular mayor is simply unconscionable. Thank you.
Okay. Motion to adjourn?
Motion to adjourn.
Second.
Okay. Motion made by Alderman Mike Seville, second Jennifer Stellings. We adjourn the meeting at 12:06.
Say aye.